All rise, veuillez-vous lever. تفضلوا بالوقوف. Please be seated. Vous s'asseoir. تفضلوا بالجلوس.
Before we start today, the Trial Chamber wishes to express its deepest sympathy to the people of Lebanon for their collective and individual losses caused by the terrible tragedy of Tuesday, the 4th of August. Let us therefore pause for a minute's silence of reflection to remember the victims of this catastrophe, those who lost their lives, those who were maimed or injured in the explosion, their families, and those who have been made homeless or suffered damage to their homes. Can you please call the case, Madam Court Officer?
The Special Tribunal for Lebanon is sitting in open session for the pronouncement of the judgment in the case of the prosecutor versus Ayyash, Meray, Onesi, and Sabra, case number STL-11-01.
Good morning to everybody. I note for the record that the 3 trial chamber judges are in the courtroom in Leidschendam, the Netherlands, and the 2 alternate judges, Judges Akoum and Judge Letiri, joining us, participating remotely from Beirut and Rome. Can we please have appearances? I will take them for those in the courtroom from the parties and participants, and please announce the appearance of anybody who is not in the courtroom but is nonetheless participating. Starting with the prosecutor.
Thank you, Your Honors. Good morning. Good morning to my learned colleagues, both in the courtroom and to those who are watching remotely. Appearing for the prosecution, I'm Norman Farrell. With me is the Deputy Prosecutor, Madam Joyce Debet, and counsel, Mr. Nigel Pavois and Mr. Mark DeSallier, and our case manager is appearing remotely. Thank you.
The Ayyash defense.
Good morning to all, Your Honor. Thank you. I'm Tom Hannes. In the courtroom with me is Anand Shah on my left, Stephanie Arian on the right, 2 rows back. On the big screen, lead counsel Emil Aoun in the lower right, and co-counsel Chad Mayer in the upper left. We represent the interests of Salim Ayyash.
صباح الخير سيد الرئيس، صباح الخير الهيئة الموقرة، صباح الخير للسادة القضاة والسادة الزملاء المحامين الذين يحضرون معنا عبر الدائرة المغلقة. صباح الخير جميع من بالقاعة. أنا ياسر حسن تمثيلا عن مصالح السيد حسين حسن ونيسي، ويتكون الفريق اليوم مني ومن السيدة ناتالي فون فستهاوزن والسيدة مود سارليف. شكرا سيد الرئيس.
صباح الخير سيد الرئيس، سيدات والسادة القضاة المحترمين، صباح الخير إلى جميع الحضور بهذه القاعة. أنا الأستاذ محمد عويني، أمثل مصالح السيد حسن حبيب مرعي، ويحضر معي في هذه الجلسة الأستاذ جاد خليل والأستاذ محمد هيداويني والأستاذ أليكس لاريير. شكرا سيد الرئيس.
Your Honours, may it please you, I'm David Young. I represent the interests of Mr. Assad Sabra with my co-counsel, Mr. Jeffrey Roberts. Thank you.
Good morning, Your Honour. I'm Peter Haynes. I appear for the participating victims together with Mr. Mohammed Matar and Ms. Nada Abdul Sata Abu Samra. I'm assisted by Larissa Albuquerque. There are 4 participating victims present.
I'll come to that in just one moment, Mr. Haynes. Thank you. Also note that the head of the Defence Office is in the courtroom and remotely her deputy is on the screen. Mr. Haynes, you said there were 4 victims, participating victims in the courtroom.
Yes. You will recognise, of course, His Excellency Sadruddin Hariri and Mrs. Yasma Flehan. New to the courtroom are 2 of the youngest participating victims. Raina Noor Flehan, the eldest daughter of Basil and Yasma, who until your recent order was the beneficiary of full protective measures, but has decided that she wishes to waive her confidentiality and be present with her mother at the judgment today. She was 5 when her father died. She has recently graduated as a civil engineer and is moving on to do a master's degree at EPFL in Switzerland. Omar Taraf is the eldest son of Ziad Taraf, who died in the 5th car in the convoy. He was 4 when his father died. He's now 19 years of age and he lives in Germany.
The trial chamber welcomes you, the victims, to the proceedings, and thank you very much for coming. And again, we extend our sympathy for the loss, which no doubt you are still suffering. Turning to the judgment. Just before 1 p.m. on Monday, the 14th of February 2005, the former Prime Minister of Lebanon, Mr. Rafiq Hariri, was travelling in his convoy in Beirut between the Lebanese Parliament and his home, Kuratum Palace. As it approached the St. George's Hotel near the coast in Beirut, a massive explosion was detonated. Mr. Hariri was killed in the blast. 21 others, including 8 members of Mr. Hariri's convoy and innocent bystanders, also died. 3 of the victims died after the explosion, 2 on the following day, and the 3rd, the Lebanese Member of Parliament, Mr. Basil Foulayhan, succumbed after lying in a coma for 2 months. At least another 226 people were injured, some very seriously. People passing in the street and working in nearby buildings sustained terrible injuries. Many buildings were badly damaged. The explosion was triggered by a suicide bomber in a Mitsubishi Canter. It's a light tarpaulin-covered truck loaded with more than 2 tons of RDX high-grade explosives that detonated as Mr. Hariri's heavily protected 6-vehicle convoy passed the St. George's Hotel. The explosives had the equivalent of 2,500 to 3,000 kilograms of TNT. The explosion left a crater in the road over 10 metres wide and almost 2 metres deep. Mr. Hariri and his convoy had been under surveillance for some months before the assassination. Those engaged in the surveillance were communicating in the field using 3 sets of mobile telephone networks. To distinguish the 3 networks, the prosecution labelled them as the yellow, blue, and red networks. The red network was the assassination team. The users of the blue and red network mobiles communicated only with each other. Another network, labelled as the green network, of 3 mobiles, was alleged to have coordinated and monitored all aspects of the operation targeting Mr. Hariri, which eventually resulted in his death. The accused Salim Jamil Ayyash, Hassan Habib Mihai, and the former accused Mustafa Amin Badreddin are alleged to have been members of this 3-mobile network. Mr. Ayyash is also alleged to have used a red network mobile. In the months before the attack, network mobiles had followed Mr. Hariri as he travelled around Lebanon. This included his trips to Beirut airport, to his villa in Fakra, north of Beirut, to his villa at Niamey, south of Beirut, when he visited mosques and churches, when he met Hezbollah's Secretary General in South Beirut, when he went to the parliament, and when he had lunch and dinner engagements. The network mobiles were also engaged in static surveillance near Karatum Palace and along some of the routes he travelled. The aim of this surveillance was to obtain information about Mr. Hariri's movements, his security detail, his level of protection, and eventually to determine a suitable method to murder him, including finding an appropriate location for the intended attack. Mr. Hariri's convoy was equipped with electronic jammers that would have blocked the remote detonation of any explosive. Thus, a vehicle-borne improvised explosive device, or a VBIED, in the form of a suicide bomber driving a light truck loaded with explosives that he could self-detonate, was chosen for the attack. Shortly after the explosion, on the afternoon of Monday the 14th of February 2005, the Al Jazeera news network in Beirut received calls claiming responsibility for the attack and saying that a video was in a nearby tree. An Al Jazeera employee cautiously retrieved the package with a video and a letter from the tree. 3 calls were made to Al Jazeera, with the last being a menacing call exhorting the immediate broadcast of the video. The callers had also first contacted Reuters in Beirut. 2 of the accused, Hussein Hassan Onesi and Assad Hassan Sabra, were alleged to have made these calls and to have observed the video collection from the tree. In the video, which Al Jazeera broadcast later that afternoon, a young Palestinian man, Mr. Ahmed Abu Adas, claimed to represent a fundamentalist group called, quote, Victory and Jihad in Greater Syria, unquote, and to have executed a, quote, resounding martyrdom operation, unquote, against Mr. Hariri as an agent of what was described as the infidel Saudi regime. The attached letter claimed that the suicide operation was carried out by, quote, the Mujahid Ahmed Abu Adas, unquote. Now, the prosecution termed this as a false claim of responsibility for the attack on Mr. Hariri. And indeed it was. The group is fictional, and Mr. Abu Adas did not kill himself in the explosion. He was not the suicide bomber. Mr. Abu Adas, a religious 22-year-old, disappeared from his home in Beirut on the morning of Sunday, the 16th of January 2005, and his family has not seen him since. Presumably, he is no longer alive. Mr. Onesi and Mr. Sabra were alleged to have arranged his disappearance by recruiting him at a mosque in Beirut in the preceding weeks in January 2005. The successful attack on Mr. Hariri was carefully planned and implemented. The 6 core Red Network mobile users were responsible for Mr. Hariri's murder on the 14th of February 2005. The yellow, blue and red network mobile users observed Mr. Hariri and his convoy's movements in the weeks and months before the attack. Some members of the red network also used blue and or yellow network mobiles. On the day of the attack, the red mobile users observed Mr. Hariri's movements at the Parliament and were present there and near the crime scene shortly before the explosion. They also coordinated the Mitsubishi Canter's movement towards the convoy. The red network users made their final calls in the minutes before the attack, and these anonymous mobiles were never used again. The false claim of responsibility video was aimed at diverting attention away from the true perpetrators. The attack was an act of terrorism that was designed to spread fear among the Lebanese population. It was committed for political and not personal reasons. Who are the accused? The four accused are Salim Jamil Ayyash, who was born on the 10th of November 1963 in Haruf, Lebanon. Hassan Habib Mereh, born on the 12th of December 1965 in Beirut. Hussein Hassan Onesi, who was born in Beirut on the 11th of February 1964. And Assad Hassan Sabra, also born in Beirut and whose date of birth is the 15th of October 1976. A fifth and former accused, Mustafa Amin Badreddin, who was also known as Sami Issa and is alleged to have been a co-conspirator, was born in Beirut on the 6th of April 1961. All five, the prosecutor alleged, are supporters of Hezbollah, a Lebanese political and military organization. The amended consolidated indictment contains 9 counts, alleging crimes committed contrary to the Lebanese criminal code. The crimes are of conspiracy to commit a terrorist act by means of an explosive device, committing a terrorist act by means of an explosive device, the intentional homicide of Mr. Hariri and of the 21 others, the attempted intentional homicide of the 226 people injured in the blast and of being accomplices to these crimes. The prosecutor alleged that each of the four accused of Mr. Badreddin participated in the conspiracy. They had the following pleaded roles in the attack. 1. Mustafa Amin Badreddin monitored and together with Salim Jamil Ayyash coordinated the surveillance of Mr. Hariri in preparation for the attack, including the purchase of the Mitsubishi Canter. He also monitored the physical perpetration of the attack and monitored with Hassan Habib Mereh the coordination of the preparation of the false claim of responsibility. 2. Salim Jamil Ayyash with Mustafa Amin Badreddin coordinated the surveillance of Mr. Hariri in preparation of the attack, including the purchase of the Canter. He communicated with Hassan Habib Mereh in relation to preparations for the attack, including the false claim of responsibility. He coordinated the physical perpetration of the attack and participated in carrying out the surveillance and assassination. 3. Hussein Hassan Onesi and Assad Hassan Sabra, under Mr. Mereh's coordination, participated in identifying a suitable person to use in a videotaped false claim of responsibility for the attack, namely Mr. Abu Adas. Immediately after the attack, they disseminated statements falsely attributing responsibility for the attack, ensured the delivery of the video and attached letter to Al Jazeera, and then ensured its broadcast. This too was under Mr. Mereh's coordination. Mr. Onesi additionally, and under Mr. Mereh's coordination, allegedly participated in Mr. Abu Adas's disappearance for the purpose of creating a false claim of responsibility. 4th, and finally, Mr. Hassan Habib Mereh with Mustafa Amin Badreddin is alleged to have coordinated the false claim of responsibility and at times was in communication with Assad Sabra for this purpose. He coordinated Mr. Onesi's and Mr. Sabra's activities in identifying and effecting the disappearance of a suitable person, Mr. Abu Adas, who would be used in the video. Immediately after the attack, he coordinated their activities in disseminating statements falsely attributing responsibility for the attack, ensuring the delivery of the video and attached letter to Al Jazeera, and ensuring its broadcast. Mr. Onesi and Mr. Sabra, according to the prosecutor, used their personal mobiles to communicate with each other and Mr. Mereh in relation to the false claim of responsibility. These 3 mobiles were termed the, quote, purple group, unquote, of mobiles. Mr. Badreddin, Mr. Ayyash and Mr. Mereh were alleged to have communicated in the closed 3-mobile green network in which Mr. Ayyash and Mr. Mereh used their green mobiles only to communicate with Mr. Badreddin. The prosecution attempted to prove that they were using the network mobiles based upon the co-location of the network mobiles with their own personal mobiles. In other words, that the personal and network mobiles made calls and travelled in a manner suggesting that they had a single user, meaning that one person was using them. The prosecution presented a vast quantity of documents and telecommunications evidence, including the call data records of the calls made and cell site evidence of the cell towers activated by the mobiles, in attempting to prove first that the accused and Mr. Badreddin were using the personal mobiles alleged, second, that these were co-locating with the network mobiles, and thirdly, that the network mobiles were engaged in Mr. Hariri's surveillance and then his assassination. The 4 accused and 5, while Mr. Badreddin was an accused person on the indictment, were tried in absentia. That was after the trial chamber had decided that they were aware of the indictment and had absconded or otherwise could not be found. The trial chamber heard evidence from 269 prosecution witnesses, 119 of whom gave live testimony in the courtroom or through video conference link, and it received the evidence of 150 witnesses through their written statements. The total number of witnesses at trial was 297. The trial chamber ordered protected measures to protect the identity of many witnesses, including 46 witnesses who testified in court. This was due to concerns for their personal safety or that of their families. It also received the evidence of 20 prosecution expert witnesses and, in respect of identification procedures, 1 Anesi defence expert witness. The trial chamber received over 3,000 exhibits into evidence from the prosecution, the defence, and the legal representatives of the participating victims. The judgment is over 2,600 pages with more than 13,000 footnotes. In addition, we have also prepared an authentic and authoritative abbreviated summary of the judgment of around 150 pages that extracts the main findings and cross-references them by footnote to the judgment. This pronouncement today is a shorter summary to publicly explain the lengthy, fully reasoned judgment which will be delivered at the conclusion of these proceedings today. Turning to the cell site and the communications evidence in general, the prosecution's case relied upon telecommunications evidence. Without this, there was no case against the 4 accused. Over the years of the investigation, the investigators examined the records of millions of calls and text messages to find evidence of communications between mobiles from which patterns could be found. This started with examining the records of the mobiles used around the Parliament and the crime scene area on the day of the attack on Mr. Hariri. The investigators, initially from the Lebanese investigating authorities, found a group of mobiles that were only communicating with each other. This group that came to be known as the Red Network had 8 mobiles. They were all anonymous. The SIM cards were all purchased in Tripoli, in northern Lebanon, in late December, early January 2005, and they were initialized there in Tripoli within minutes of each other on 4th of January 2005. Their credit was topped up in Tripoli on the 2nd of February. 5 handsets were bought together also in Tripoli in late December 2004. The 6 principal mobiles on this Red Network all made their last calls in the minutes before the attack on Mr. Hariri. They were never used again after that. This group of mobiles was completely anonymous. There were no calls outside the group and no texts were sent within it. The only evidence the investigators had of their use was the cell towers to which they were connecting and when, and which numbers they were calling. From this, they tried to find out who was using them and who were the callers. The investigators then examined other mobiles that were in the same cell sectors at or around the same time. They were trying to find out if other mobiles were co-locating with the red network mobiles. They did what is called a, quote, cell dump, unquote. Now that involves examining the records of all connections to specified cells and filtering for which mobiles are contacting each other or contacting others. They look for patterns and then repeat this with target mobiles in other cells that the mobiles connect to. They were trying to find whether mobiles were doing what's called co-locating. Now, co-locating simply means that the mobiles are travelling together in such a manner that one person could be using more than one mobile. To illustrate, a common example is of someone carrying both their work and personal mobile around with them in their pocket or their bag. When two mobiles are together, they will connect to the same cell towers. The mobile can be identified through the unique number of each handset and the SIM card that every mobile has. Now, normally, we might expect that a work mobile will be predominantly used during working hours, and a personal mobile more frequently used out of work hours and in different areas. But whichever it is, most people leave a distinct geographic signature when using their mobiles. Most people habitually use their mobiles in the same areas, and for example, don't use them at night when they're at home asleep. They may receive SMS messages when they are not using the mobile because they are sleeping, but the cell where the mobile is when it receives the text is recorded in the call data records. Thus, we can normally know where a mobile was during the night unless it was switched off. The first use of a mobile in the morning and the last use at night leaves clues as to where the user is staying that night. Most people also have a pattern of contacts in who they call, text, and message. This too can provide clues as to who is using it. If investigators have the mobile in their hands, they can of course examine it for other clues, such as notes, photographs, encrypted messages, and so on. But the investigators here only had the cell tower connections to go on. Every cell tower has an area of what is called its predicted best server coverage area, which is normally divided into 3 triangular cells on each tower or mast. That simply means the place it is predicted that your mobile will connect to cell A as opposed to cell B or cell C. Each cell has its own name, but this isn't an exact science, as the predicted best coverage areas overlap, especially around the edges, meaning that your mobile can potentially connect to more than one cell. Or if the network is congested, the call may be directed to the next available cell, which will be one of the cells surrounding the one that the mobile actually physically is in. To work out if mobiles are co-locating requires some cell site expertise. Someone who understands cell coverage areas, the principles of radio propagation, radio wave propagation, and how mobile networks operate. These experts will examine the call patterns of the target mobiles to work out if it is possible, and it is stressed here possible, that 2 mobiles could have a single user. Sometimes no particular expertise is needed to work this out. For example, if 2 mobiles always connect to the same cells at the same time every day, or if 2 mobiles make separate calls in different cells, but where it's possible to travel the distance between the cells in the time between the calls. For example, 2 cells 2 kilometres apart with calls made in each cell within 15 minutes of each other. But this can be far from straightforward, as mobiles connect to cell towers by radio propagation. The radio waves from the cell and the mobile will hit and bounce off buildings and hills and other geographical features, and can take shortcuts across water far from a predicted coverage area. This can make it difficult to pinpoint where the mobile is. The networks use their own predictive software to show the predictive best server coverage of each cell tower, each cell on a tower. This is for commercial reasons, to provide the best coverage possible for their customers. They can change the coverage area by adjusting the cell tower antenna, by changing its angle up or down, for instance, or installing a relay station, or in extreme circumstances, a new cell tower. The predicted coverage areas also don't come in neat semicircular triangles. Rather, because of topography, including tall buildings, these can be very patchy, meaning that bits of the predicted coverage of cell A can be in the middle of the predicted coverage area of the neighbouring cell B. Someone using a mobile on the eastern side of a 6-storey building could connect to a different cell to someone using it on the western side or the ground floor. The cell you connect to while walking in the street might not be the one that your mobile connects to while you are using it in the back garden of a house in the same street. So some expertise is required to interpret the call connections. And as a further complication, the trial chamber received evidence that Lebanon's Alpha telecommunication networks predicted best serverage coverage maps of 2004 and 2005. Covering the indictment period were only around 60 to 70% accurate. Now that's good enough for the network's commercial purposes, but it's not good enough to pinpoint precisely where a mobile is. So a mobile's connection to a cell can only approximate where a mobile is, and this is only to the extent that it will be most probably connecting to the cell that provides the predicted best coverage area to where the mobile actually is. In this case, that was the only evidence that the prosecution had of where the mobiles were. That is, the personal and network mobiles that the prosecution said that the 4 accused and Mr. Badreddin were using. There was no GPS to isolate their location, and no direct evidence of who was using a mobile and when and where. There were no smartphones in Lebanon in 2004 and 2005. The case was entirely circumstantial. The only exceptions were when witnesses testified as to where they were at a particular time, and the cell site data of their mobile connections matched this. This was particularly important in pinpointing Mr. Hariri's locations when he was under surveillance. His bodyguards used their mobiles, and the media covered his appearances. His office kept records of where he went and when, and of his numerous trips out of Lebanon. Putting these things together, it is possible to conclusively establish where he was and whether any network mobiles were nearby at the same time. If they were, the trial chamber could then consider whether the network mobiles were conducting surveillance of him, or, alternatively, if their presence there was simply coincidental when compared to where they were before and afterwards. For example, if Mr. Hariri visited a church and the network mobile started connecting to cells covering the church, or he went out to lunch and the same thing happened, or he travelled to his Fakra village about 50 kilometres north of Beirut in the Furaya area, and the network mobiles were suddenly connecting to cells along the route on his way there and back, patterns emerge. And it is the consistency of these patterns that allows conclusions that these things are beyond coincidence. The trial chamber heard evidence of all of these facts. What has just been said is a way of explaining it in a simplified manner for the purposes of this pronouncement. It's explained in much greater detail in the summary and in the judgment. The trial chamber heard a lot of evidence about whether the prosecution's cell site evidence was reliable. The trial chamber has concluded that it was sufficiently reliable to use to establish where mobiles generally were. This is reliable enough to establish the patterns of travel of multiple mobiles. For example, if they travel in the same direction in a manner in which collocation is possible, and the sample size is sufficiently large to draw this conclusion, meaning the more calls, the longer the period, and the more they travel. But it is nowhere near 100% reliable. But this is not necessary to establish these patterns. It becomes more important when precision is needed to place someone at a certain place, like a particular payphone or a mosque or a tree, at a specified critical time. If someone is alleged to have used a certain payphone at a particular time, and the only evidence of this is that their mobile connected to a nearby cell at around that time, this is far more difficult to prove. The prosecution and defense used what are called call sequence tables to show the call connections, cells, mobiles, and texts. These are extracts from the call data records of the telecommunications companies put into tables. Without these, the call data records are just strings of incomprehensible numbers. Turning to a fundamentally important matter, the standard of proof. The prosecution must prove the guilt of the accused beyond reasonable doubt. The accused are presumed innocent until a verdict of guilt is entered against them. The trial chamber considered every crime and charge against each accused individually, determining for each whether the evidence establishes beyond reasonable doubt all facts indispensable to a conviction. The trial chamber judges voted separately on each charge in the indictment, and also, if necessary, to make separate findings on whether each accused was guilty as charged. The verdict here is unanimous on each count. The trial chamber has assessed each piece of evidence in the context of all related evidence. Taking this approach is particularly important in evaluating the prosecution's telecommunications evidence. The evidence against the four accused, as said earlier, is almost entirely circumstantial. It is only from reviewing the relevant facts in their entirety that a chamber can see patterns that could potentially emerge, from which conclusions could be drawn that they are so striking as to be beyond coincidence, and hence provide proof beyond reasonable doubt of facts that are indispensable to a conviction. The trial chamber is also acutely aware of the difficulties in attempting to assess the reliability and credibility of witness testimony, especially in an international setting, through interpretation, and many years after the attack on Mr. Hariri, in evaluating the evidence of each witness. Turning to the political background and context to the attack. The trial chamber received extensive evidence from the prosecution and also the defence of Mr. Hussein Hassan Anesi concerning the political and historical background to the attack on Mr. Hariri. Mr. Marwan Hamadeh, Mr. Walid Jumblat, Mr. Fouad Signora and Mr. Jamal Sayed and other politicians and Lebanese officials testified about the events leading to Mr. Hariri's assassination. The trial chamber, it is stressed, has no role as a trial court in either writing or correcting any version of history that witnesses or anyone may have urged upon it. Its role is to decide only whether the four accused are guilty beyond reasonable doubt of any of the charges on the indictment. The attack on Mr. Hariri, however, did not occur in a political or historical vacuum. The trial chamber cannot ignore the background to the attack as providing a possible motive for it. Motive, though, is not a legal element of any of the crimes charged. The assassination by car bombing of a prominent politician who had recently resigned as the Prime Minister and was preparing to contest the next parliamentary elections was undoubtedly a political act. Understanding the political background to the attack gives context to why Mr. Hariri was targeted in this manner, but only as it relates to whether the accused on trial are guilty of any counts charged on the indictment. The evidence showed Syria's overwhelming political, military and economic dominance in Lebanon after the end of the tragic civil war. Opponents of the Syrian presence included Mr. Jumblat's Druze political faction, Christians and members of Mr. Hariri's own future movement. Mr. Hariri's political allies vocally supported a United Nations Security Council resolution, number 1559, which, in September 2004, called for the disarming of militias in Lebanon and the withdrawal of foreign troops from Lebanon. One militia was Hezbollah's. The soldiers were Syrian. The Syrians even imposed electoral candidates on Mr. Hariri. These were known as the, quote, Syrian deposits, unquote. Mr. Hariri resisted. He did not want this. The Syrian government, over Mr. Hariri's opposition, also wanted to extend President Emil Lahoud's term-limited mandate. This could only be done by the Lebanese parliament changing the constitution. In August 2004, the Syrian president, Mr. Bashar al-Assad, effectively ordered Mr. Hariri to support Mr. Lahoud's mandate extension, stating that Syria alone would choose the president of Lebanon. In the months before his assassination, Mr. Hariri's allies were publicly calling for an end to the Syrian political, military, and economic dominance over Lebanon. His supporters held 3 meetings in the Bristol Hotel in Beirut and issued calls for the end of Syrian domination of Lebanon. These occurred in September and December 2004, and a final one just 12 days before his murder. That occurred on the 2nd of February 2005. These meetings came to be known as the Bristol Group meetings. There was also an attack on the life of Mr. Hariri's political ally and friend, Mr. Marwan Hamadeh, on the 1st of October 2004, when a car bomb exploded outside his house. Mr. Hamadeh escaped death and was seriously injured in the attack, but his bodyguard died and another person was seriously injured. Witnesses testified that the attack on Mr. Hamadeh could be construed as a warning to Mr. Hariri and Mr. Jumblat not to cross the line in relation to the Syrian regime. Mr. Hariri resigned as Prime Minister on the 20th of October 2004 and was planning to run in the May 2005 elections. He would have been proposing the loosening of Syrian dominance over Lebanon and the immediate withdrawal of Syrian troops from Lebanon. The Syrian government, however, was supporting a new electoral law designed to diminish Mr. Hariri's chances of having members of his bloc elected to parliament, and hence his prospects of a new term as Prime Minister. The Syrian government was also insisting, over Mr. Hariri's opposition, that he accept the so-called Syrian deposits in his electoral list. Mr. Hariri also regularly met senior Syrian officials operating inside Lebanon. These included the chief of Syrian military intelligence in Lebanon, Mr. Rustam Ghazali. Over more than 11 years before his death, from 1993 to 2005, Mr. Hariri paid millions of US dollars and in regular cash payments to Mr. Ghazali. This included, significantly, a double payment on Sunday the 13th of February 2005, the day before the attack on Mr. Hariri's life. The payments were seen as a form of blackmail necessary to preserve the relationship. The trial chamber is also satisfied that Mr. Ghazali had a good reason to demand this timely final double payment from Mr. Hariri. The growing opposition to the Syrian presence in Lebanon threatened Syria's interests. The trial chamber is of the view that Syria and Hezbollah may have had motives to eliminate Mr. Hariri and some of his political allies. However, there was no evidence that the Hezbollah leadership had any involvement in Mr. Hariri's murder, and there is no direct evidence of Syrian involvement in it. The trial chamber also received evidence that Hezbollah's Secretary General, Mr. Hassan Nasrallah, and Mr. Hariri had good relations in the months before the attack, and that Mr. Hariri supported the disarming of Hezbollah's militia only once peace with Israel was achieved. For the reasons set out a little later in this pronouncement, the trial chamber has found that the date when the conspirators decided to proceed with the attack on Mr. Hariri's life coincided with two important events in early February 2005. These were first, a visit to his home by the Syrian Deputy Foreign Minister, Mr. Walid El-Mualim, on the 1st of February 2005, and second, the next day, a third meeting of the anti-Syrian opposition at the Bristol Hotel in Lebanon. I turn to Judge Nosworthy, who will read the next portion of the judgment.
The trial chamber now deals with the victims. The explosion had a terrible, devastating, and dramatic impact and effect on its victims. Participating victims provided direct evidence of the terrible consequences of the attack. Families lost spouses, parents, siblings, carers, children, and other close relatives. Some suffered catastrophic injuries. 15 and a half years later, the scars remain. Some still suffer from post-traumatic stress disorder. Many have permanent injuries. There is no doubt that terrorism is one of the most serious and heinous crimes, and that the attack was very grave. The gravity of the crime encompasses its impact on the victims. The harm suffered by the victims, the lost lives, personal injuries, or the loss of a family member, cannot be restituted as restoration of the original situation of the victim before the violation is impossible. The judgment highlights what happened to many victims. The trial chamber cannot order reparations, but it may identify victims, which may assist them in claiming compensation before a national court or other competent body. The trial chamber is satisfied beyond a reasonable doubt that direct and indirect victims suffered harm. The disparity in treatment among the participating victims as to, quote, compensation, unquote, meaning financial, for the loss or damage suffered was dramatic. Some victims received money from a state body, others from the Hariri family. Most received nothing. Victims who provided evidence felt a real sense of injustice because some were compensated while most were not. Compensation for victims of serious crimes must be appropriate and proportional to the gravity of the harm suffered. It should not depend on the circumstances of the victims, their connections, employment relationship, or insurance scheme. As a general proposition, The trial chamber agrees that victims of crimes should be entitled to receive a form of statutory compensation. The trial chamber, at the invitation of the legal representative of victims, reminds the Lebanese government of the UN Declaration of Basic Principles of Justice for Victims of Crimes and Abuse of Power, of the need for just compensation, quote unquote, for the victims of crime. It also reminds the Lebanese government of the importance of having an adequate compensation scheme for victims. As an alternative, a voluntary trust fund could be established to compensate the victims in the cases within the tribunal's jurisdiction. We now turn to the attack. Turning to the attack in more detail. On the morning of Monday, the 14th of February, 2005, Mr. Hariri left Kuratum Palace to attend a morning session of the Lebanese Parliament. Shortly after 12 noon, he left Parliament and went to the Café Place de l'Étoile, opposite where he stayed for around 45 minutes. At around 12:45 p.m., he left the cafe and asked his security detail to prepare his convoy to go back to the palace to attend a luncheon appointment. At around 12:49, he entered his armored vehicle, accompanied by Member of Parliament, Mr. Bassel Fuleyhan. At approximately 12:55, as the convoy passed a Mitsubishi Canter on Rue Minet El Hossein, outside the St. George's Hotel, the suicide bomber detonated the explosives. Mr. Hariri was driving himself. Seated next to him was Mr. Bassel Fuleyhan, MP. His car was the third in the convoy. Behind him were two more vehicles, and a makeshift ambulance followed the convoy. It had an internal security forces, or ISF, lead escort. The explosion occurred around 40 to 50 meters behind the lead vehicle in Mr. Hariri's convoy. Witnesses described two deep sounds, a second apart, a huge roaring sound, and a wave of hot pressure, a huge explosion, the sound of an aircraft going through the sound barrier, or a missile thrown by a large artillery gun. They also described it like an earthquake. The explosion was heard throughout the city, up to 25 kilometers away. While some could barely remember the ordeal due to the injuries and shock, and described it as, quote unquote, dreamlike, many gave a vivid account of the explosion and immediate aftermath. It severely damaged nearby buildings, such as the HSBC Bank. 70 to 80 firefighters arrived to try to put out the fire. Mr. Fuleyhan survived the immediate impact of the explosion. He was transferred from the American University of Beirut Medical Center to France for treatment, where he succumbed to his injuries only 2 months later. In February and March 2005, the Lebanese military intelligence and internal security forces conducted their own investigation and analysis of the explosion. Following a request from the Lebanese Prime Minister, the UN Secretary General dispatched a fact-finding mission to Beirut to inquire into the causes, the circumstances, and the consequences of this assassination. The investigation was not conducted according to international standards. It was mismanaged, disorganized, and there was a chaotic approach to the crime scene investigation, particularly in the initial period after the explosion. The crime scene was not properly secured. Critical evidence in the form of the vehicles in Mr. Herrera's convoy were removed by the ISF from the crime scene on the very evening of the attack. Tow trucks and other heavy-duty vehicles drove onto the crime scene in order to do this. The crime scene was damaged. It was also unnecessary. There was no urgency. The trial chamber finds incomprehensible what happened. There was no proper coordination of the initial investigation. There was, in the trial chamber's view, no coordinated procedure to search for missing persons in the days following the explosion. The body of one victim was found only after repeated attempts by his family to search for him at the crime scene on their own, and on one occasion with search dogs which they brought on site and paid for themselves. They found his body some 17 days afterwards. Another victim's body was found the day after the explosion and was probably alive for 12 hours afterwards and may otherwise have survived had he received timely medical treatment. In the year after the explosion, international forensic teams from Switzerland, the Netherlands, the United Kingdom, and Spain assisted the international investigators from the UN fact-finding mission and the UNIIC. That's the United Nations International Independent Investigation Commission that was established by the Security Council in April 2005. It assisted the Lebanese investigating authorities until February 2009. The trial chamber is, however, satisfied that Lebanese officers and experts, but assisted by multiple international forensic teams, conducted some thorough and successful investigations into various aspects of the explosion and in very difficult circumstances. This included explosives, ballistics, and forensic crime scene investigation, including Lebanese volunteers and international underwater diving teams and experts in identifying vehicle parts, and forensic science and human identification. The various investigations collected key evidence at the crime scene, such as the vehicle parts and some of the human remains. The gross deficiencies in the initial investigation, in our view, did not affect in any material manner the evidence underlying the issues that required the trial chamber's deliberation on the guilt of the accused. However, strong lessons must be learned from what occurred. We now move on to the explosion. The attack was a detonation reaction of high explosives. The damage and destruction to the St. George's and Byblos hotels demonstrated the nature of the explosion. The St. George's Hotel, for example, suffered a bent column and canopy. A 3.5-meter section of the 20-centimeter thick front wall of the Byblos Hotel was pushed back 60 centimeters by the explosion. The mangled metal fragments found at the scene of the explosion and the presence of what is called, quote, washout, unquote, on several of them further confirms that high explosives were used during the attack. This was an enormous explosion. The quantity of explosives used was between 2,500 to 3,000 kilograms of TNT equivalent. The explosive used is RDX, which is also available as Semtex. Some witnesses observe that RDX is so powerful that it is most suitable for military purposes. It was detonated approximately 50 to 80 centimeters above ground level, and the explosive charge was rectangular in shape. It created a crater that, based on the cone shape, had a diameter of around 11 to 4 meters with a depth of around 1.9 meters within a margin of error of several %. The expert evidence was that an explosion in a narrow street with tall buildings with few openings will create higher peak pressure and peak impulse values because of reflections from nearby walls. This is known as the canyon effect, quote unquote. The explosives were loaded on the cargo tray of the back of a white Mitsubishi Canter, a common type of light truck covered in a tarpaulin. This vehicle, stolen in Japan, was imported into Lebanon from the United Arab Emirates in December of 2004, and then sold in Tripoli in mid-January 2005 to 2 unknown men. Parts of the canter were recovered at the crime scene and in the waters of the nearby port. The engine block identifies it as the Japanese canter. Mr. Herrera's convoy was equipped with jamming devices designed to prevent a remote detonation of a bomb. They were activated and working on the fatal day. The consensus of the various Lebanese and international investigation teams was that a suicide bomber triggered the explosion. The trial chamber agrees. Each team eliminated the other possible means of detonation as inappropriate for targeting a moving convoy of vehicles. This leaves only the possibility of a remote control device or a suicide bomber. The trial chamber has found beyond a reasonable doubt that a suicide bomber triggered the attack. 23 people died in the explosion or in the aftermath of the blast, including the suicide bomber. However, only 20 complete bodies were recovered from the crime scene. The remains of an unidentified man were found near to the blast. In total, the experts and investigators recovered and identified 92 human parts belonging to him. The quantity of remains was small, with a combined weight of less than 1 kilogram. This included smaller pieces of tissue and bones. A burnt tooth sample from this person did not match the DNA profile of Ahmad Abu Adas, the young Palestinian man in the false claim video. His DNA profile was not found at the crime scene. Based on the DNA evidence found at the scene and the analysis of DNA samples from Mr. Abu Adas's family members, the trial chamber is satisfied beyond a reasonable doubt that Mr. Abu Adas was not the suicide bomber. The unidentified male was the closest in proximity, within 1 to 2 meters of the explosive device when it detonated. He was most likely the suicide bomber in the trial chamber's opinion. Beyond the evidence that the tooth belonged to a young male in his early 20s, there is no further identifying evidence in the human remains analyzed by the forensic experts on his identity. The trial chamber, therefore, cannot make a finding on the unidentified male's identity. We now turn to the mobile telephone networks. The prosecutor alleges that the four accused and Mr. Badreddin carried out Mr. Hariri's assassination by using groups of mobiles that operated as networks. These were mobile groups with a high frequency of contacts within the group. The green network of 3 mobiles allegedly monitored and coordinated the attack and the false claim of responsibility. The red network of 8 mobiles carried out the assassination of Mr. Hariri. The blue network of 15 mobiles and the yellow network of 13 mobiles were used to prepare for the attack, including the surveillance of Mr. Hariri. The 3 mobiles in the 5th group, the purple mobiles, were used to communicate with each other and others outside the group to coordinate the false claim of responsibility. This may sound complicated, and indeed it is or was very complicated trying to unravel what occurred by examining cell site and call data records. The handsets and SIM cards were purchased anonymously or with fake identification and paid in cash, including top-ups. Some handsets were swapped between mobiles in different networks. The trial chamber finds that the green, red, blue, and yellow networks were interconnected and coordinated with each other and operated as covert networks at the relevant times. The assassination team used 6 red mobiles, including on the day of the attack. At least 2 also used blue mobiles. Given their high forensic profile, the discovery of the red mobiles by investigators was inevitable. They were used in the area of the crime scene at the time immediately preceding the crime. The red network mobiles ceased use just before the explosion. Their users took extra care to limit their traceability, which meant that the anonymity of the users of the red mobiles was the most protected. This created a need for the blue mobiles, which could be used more generally for surveillance and other activities. As to attribution of the mobiles to the 4 accused and Mustafa Badreddin. The case against the 4 accused and proving Mr. Badreddin's pleaded role in the conspiracy charged depends upon the prosecution successfully proving that they were using specified mobiles. This is termed attribution, quote unquote. Proving this attribution of specified personal mobiles is the first step towards co-location of the network mobiles and their attributed personal mobiles. This part of the prosecution's case is factually very, very complicated. Neither the accused nor Mr. Badreddin had mobile subscriptions in their own names, which could have made the attribution analysis easier. The investigation worked backwards, quote unquote, by first identifying the patterns of mobile use in suspected closed networks that appeared to be connected with the surveillance and or assassination of Mr. Hariri, and then attempting to find mobiles that were co-locating with these identified network mobiles. They then had to identify who was using the mobiles that appeared to be co-locating with the network mobiles. Finally, this had to be connected to any known and provable events linked to the crimes. The investigators closely examined the circumstances surrounding the mobile use to attempt to find their users. The UNIIC and the prosecution engaged in a complex and time-consuming inquiry, checking for everything that could be gleaned from the associations, in inverted commas, of a targeted mobile, attempting to determine who was using it, to connect it with a suspect, or to identify a potential new suspect. This inquiry included analyzing each mobile's pattern of use, such as where it was used, who it was in contact with, and how often and who its contacts contacted. I now turn over to Judge Brady.
Taking the four accused in turn, Salim Jamil Ayyash. According to the indictment, he was using 4 network mobiles, termed Yellow 294, Blue 233, Red 741, and Green 300. Mr. Ayyash owned an apartment in Hadath, Beirut, and used a family residence in Harouf in southern Lebanon, near Nabatie. He worked for the Lebanese Civil Defense at the Al-Duwair station near Harouf until February 2002, and then until November 2004 was the head of the Markaba station before transferring back to Al-Duwair. The prosecution led evidence of his personal mobile and landline use and the contacts of each number and what was termed the geographical profile, namely the cells that the mobiles were connecting to. This means where they were when they made and received calls. The numbers calling and called and texts sent and received were termed the contact profile. The same technique was laboriously used with each mobile in the case and with each accused. From this, the investigators compiled a profile on each mobile that the prosecution used to submit that only the named accused person could have been using the particular mobile in question. Mr. Ayyash used the landlines at the 2 properties which were in his name and personal mobiles numbered 165, 170, 935, and 091. These mobiles had similar contact profiles and were used as contact numbers for official and business purposes such as passport applications, family service providers, and for insurance claim and towing after his car was involved in an accident. The SIM of one was used in his BMW. He also traveled to Mecca to perform the Hajj in January 2004. While he was there, he used his bank card to withdraw cash from ATMs. The importance of this to the case is to compare his mobile usage then with his mobile usage a year later when he allegedly made another pilgrimage there. In January 2005, Mr. Ayyash was again recorded as traveling to Saudi Arabia from Beirut between 15 and 28 January. If he was not in Lebanon then, he could not have been using the 3 network mobiles, red, blue, and green. It would have to have been someone else. The prosecution case against him would fail on that basis alone. To prove that Mr. Ayyash remained in Lebanon, the prosecution compared the call patterns of the mobiles that Mr. Ayyash was using in January 2004 with those he was using in January 2005, and additionally their collocation with the Yellow Network mobile in 2004, number 669. Its SIM was also used in Mr. Ayyash's personal mobile 170. The trial chamber has found, but only on the preponderance of the evidence, namely the common movement and the number of overlapping cell activations, that it is more likely that Mr. Ayyash was Yellow 669's principal user. The Lebanese border records and the flight manifest of Middle East Airlines show Mr. Ayyash leaving Lebanon for Saudi Arabia with his wife and daughter on 15 January 2005. He had obtained a special Hajj passport for the travel and had taken time off work for pilgrimage. However, his leave was cancelled, and he was reimbursed a travel allowance on the basis that he was working for the civil defense, involved in duties such as firefighting and rescue work. Additionally, the trial chamber received evidence that the passport control system at Beirut airport at the time was inadequate as it was overwhelmed by thousands of pilgrims. Pilgrims with Hajj passports were checked in as a group, and their passports were collected as a group and given to the border officials for stamping. Individual identities were not checked. The Saudi records show Mr. Ayyash and his wife's names as entering and leaving, but not their daughter, who the Lebanese recorded as leaving and entering Lebanon. The system was flawed and unreliable at both ends. Mr. Ayyash's attributed network mobiles, Blue 233 and Green 300, remained active during the 2005 Hajj, and Red 741 started its network activities. The mobiles continued to collocate and move in tandem in the periods analyzed, including the 2005 Hajj. In contrast with personal mobile 165's handset change during the 2004 Hajj, personal mobiles 170 and 091 continued to use the same handset before and after the 2005 Hajj. These personal and network mobiles had a single user during the 2005 Hajj, except for the duration of mobile 091's separation from the other mobiles on the afternoon of 28th of January 2005. The trial chamber had therefore found that Mr. Ayyash remained in Lebanon and did not travel to the Hajj. This finding is essential for deciding whether he was involved in the attack. The evidence established that he was using Yellow 294 until 7 January 2005, based upon its collocation with his personal mobile 935 and their common calling patterns. Blue 233 was used for preparations in the attack on Mr. Hariri, including surveillance. It was used by Mr. Ayyash from Monday 10 January until at least 14 February 2005. Its collocation with Mr. Ayyash's personal mobiles 170 and 091 was such that the trial chamber finds that they had a single user. Mr. Ayyash, according to the prosecutor, was Green 300's user from 30 September 2004 to Monday 14 February 2005 as one of 3 mobiles that were used to monitor and coordinate the preparation for the attack on Mr. Hariri. This mobile contacted only one other, Green 023, that the prosecutor attributed to Mustafa Badreddin. Green 300 made its final call on 14 February 2005, an hour before the attack on Mr. Hariri, connecting at the end of that call to a temporary relay cell placed on the back of a truck across the road from the Phoenicia Hotel, facing in the hotel's direction and close to the scene of the attack. This small temporary cell had a predicted coverage area of around 150 meters. The cumulative occurrences of possible collocations between Mr. Ayyash's personal mobile 935, 091, and 170 and the network mobiles Yellow 294 and Blue 233 with Green 300 over this period of 4.5 months has convinced the trial chamber that these mobiles had a common user in Salim Ayyash. Red 741, according to the prosecutor in the amended consolidated indictment, was one of 6 red mobiles used by the assassination team. The prosecution attempted to prove that Mr. Ayyash was using it through its collocation with Mr. Ayyash's personal mobiles 091 and 170 and the network mobiles Blue 233 and Green 300. The attribution of this mobile is the key to the case. Whoever was using it was closely involved in Mr. Hariri's murder. Red 741 dislocated from mobile 091 on Wednesday 2nd February 2005 when it was topped up in Tripoli. Logically, whoever was topping up a group or network of mobiles took the mobiles from their individual users to Tripoli. The trial chamber is satisfied beyond reasonable doubt, based on the totality of the evidence, that Red 741 also had the same user as these other mobiles analyzed above. That user was Mr. Ayyash from Friday 14 January to Monday 14 February 2005. The trial chamber is therefore satisfied beyond reasonable doubt that Mr. Ayyash was the user of Red 741 from Friday 14 January to Monday 14 February 2005. The evidence also established that Mr. Ayyash had affiliation with Hezbollah. Hassan Habib Mer'i. The next accused is Hassan Habib Mer'i, who was alleged to have used his personal mobile, Purple 231, to organize the false claim of responsibility for the attack. Allegedly, he communicated with Mr. Badreddin exclusively on a green mobile number 071. The case that Mr. Mer'i was using either Purple 231 or Green 071 is circumstantial. Purple 231 was not subscribed in his name and was last used on Tuesday 15 February 2005, the day after the attack. The prosecution sought to establish that Mr. Mer'i was using Purple 231 by proving that he and his family were using a personal mobile number 6091 and then comparing the geographical and contact profiles of the two mobiles. From this, it then sought to demonstrate that purple 231 and green 071 were collocating in a manner proving that the two mobiles had a single user, namely Mr. Murray. The evidence proves that Mr. Murray and his family were using mobile 6091. The strongest piece of evidence linking purple 231 with him was in November 2004 when someone calling from purple 231 called a furniture store and gave the name Hassan Murray for the delivery of mattress to his address and giving the contact number of mobile 6091. During the trial, another mobile, termed the Grey Mobile, was put into evidence by the Murray defense as one potentially collocating with Green 071, meaning that it was not Mr. Murray who was using purple 231. However, the prosecution then investigated the Grey Mobile and found evidence that incontrovertibly proved that Mr. Murray was its user. He was identified by his passport photograph, the mobile number, and SMS content, but it was collocating with purple 231. The trial chamber has found beyond reasonable doubt, based on the Grey Mobile, that Mr. Murray was using purple 231 at the relevant time. Whether Mr. Murray was using green 071 rests solely upon its collocation with purple 231 and the Grey Mobile. There is some reasonable evidence that the three mobiles could be collocating, but ultimately there was insufficient evidence to make a finding to the high standard of beyond reasonable doubt that Mr. Murray was using green 071. There were an adequate number of calls and significantly a lack of movement from which it could positively conclude that green 071 was collocating with either purple 231 or the Grey Mobile in a manner in which the two personal mobiles plus green 071 had a single user. The trial chamber was not satisfied beyond reasonable doubt that Mr. Murray was using a green network mobile. Hussein Hassan Onaisi. Hussein Hassan Onaisi was previously known as Hussein Hassan Isa. The prosecutor alleged that he was using his personal mobile Purple 095 in the forced claim of responsibility. It was not subscribed in his name. It was last used on Wednesday, 16 February 2005. Numerous documents, such as applications to open bank accounts and to purchase a vehicle, use this as a contact number for Mr. Onaisi, who was then known as Hussein Isa. The call data records demonstrate that a significant number of the top 30 contacts are with numbers attributed to Mr. Onaisi's family, in-laws, and acquaintances. Most notably, the highest ranking contact is with a number attributable to his mother, with which Purple 095 had 747 contacts. The totality of the evidence points to him as its principal user. The only conclusion reasonably available from the totality of the evidence was that Mr. Onaisi was the principal user of Purple 095 from at least 9 January 2003 until 16 February 2005. The trial chamber is satisfied of this beyond reasonable doubt. Asad Hassan Sabra. Mr. Sabra married Mrs. Hala Saloom in November 2000, and they lived in Beirut. He is alleged to have used a personal mobile, Purple 018, between November 2001 and 16 February 2005, and for false claim-related activities. This mobile had numerous contacts with family members of both. To prove he was using this mobile, the prosecution used two other mobiles, numbers 546 and 657, that were used from 24 February and 20 July 2005, respectively, to attribute Purple 018 to Mr. Sabra. There is no direct evidence of who Purple 018 belonged to. It had no subscriber details. There was no evidence of its use as a contact number for anything. The prosecution relies on its contact profile, the content of 6 SMS messages, the cells to which it connected, and the contact and geographical similarities, including text message content with 2 mobiles that were used after this one. This is the weakest of any of the attribution evidence led against the 4 accused and Mr. Badreddin. No conclusive evidence was presented about exactly where Mr. Sabra lived during the indictment period, namely from late 2004 to early 2005, nor with whom, nor where he worked, nor what he did. Mr. Sabra, on the prosecution's case, was using Purple 018 until Wednesday, 16 February 2005, when it was discarded. There was no evidence of a geographical footprint that could be traced to Mr. Sabra by virtue of his home address, place of work, and his leisure and social activities, including those with his family, nor for his wife, Mrs. Saloom, another potential user of Purple 018. The evidence attributing Purple 018 to Mr. Sabra is weak. Without examining mobiles 546 and 657, it cannot be attributed to him, nor could the trial chamber conclude that he was its user during the relevant period. Mr. Sabra and his wife, Mrs. Saloom, used both mobiles, 546 and 657, although it appears that they were more often used by Mrs. Saloom. The evidence establishes that Mr. Sabra and Mrs. Saloom were using Purple 018 from 22 November 2001 until 16 February 2005. They then used mobile 546 and 657. The trial chamber, however, has been unable to find calling patterns for the users of Purple 018 from which it could discern that it has a single user, either in the attribution period or the pleaded indicted period. On some days, assuming that Mr. Sabra was more likely to contact his relatives than his wives, and vice versa, either could have been using the mobile at different times. The trial chamber, therefore, cannot conclude that Mr. Sabra was the sole, main, or principal user of Purple 018 during the period pleaded in the indictment period for his involvement in the conspiracy charged, namely from 22 December 2004 to 14 February 2005. The evidence points to shared use with his wife. The trial chamber cannot positively conclude from the only evidence it has, namely that of the mobile's geographic and contact profiles, for there is no conclusive relevant text message content that Mr. Sabra was the sole user of the mobile on the days on which it is pleaded that he was using the mobile for any false claim of responsibility-related activities. The Tri-Chamber is therefore unable to conclude beyond reasonable doubt that the only inference reasonably available from the evidence is that Mr. Sabra was a single user of the mobile between 22 December 2004 and 14 February 2005. This is fatal to the case against Mr. Sabra. Former accused Mustafa Amin Badreddin. Mustafa Amin Badreddin was twice married with 6 children. His late brother-in-law was Imad Mghniye, who was married to Mr. Badreddin's sister Saada. Mr. Badreddin was one of the 4 original accused in this case when it started, before Mr. Merai's case was joined. In May 2016, Hezbollah announced his death as a Hezbollah commander fighting in Syria. On 11 July 2016, the Tri-Chamber, acting according to Appeals Chamber's majority decision, terminated the case against him without prejudice to resuming the proceedings should evidence that he is alive be adduced in the future. His name remained in the amended consolidated indictment that the prosecutor filed following this order. In this, it is alleged that Mr. Badreddin, who also used the alias Sami Isa, participated in a conspiracy with the 4 accused aimed at committing a terrorist act to assassinate Mr. Hariri. Specifically, he monitored and with Mr. Ayyash coordinated the surveillance of Mr. Hariri in preparation for the attack and the purchase of the canter used in the attack. Additionally, the prosecutor alleged that he monitored the physical perpetration of the attack and that he monitored and with Mr. Merai coordinated the preparation of the false claim of responsibility for the attack. His involvement in the attack, according to the prosecutor, is shown by using a green network mobile. Mr. Badreddin is alleged to have used his green network mobile 023 to communicate with Mr. Ayyash, who was using his green mobile 300, and with Mr. Merai, who was using green mobile 071, to exchange information regarding all aspects of the conspiracy and coordinate the acts done in furtherance of the conspiracy. It was a coordination network used exclusively by these 3 co-conspirators. Mr. Badreddin is also alleged to have been, as are the 4 accused, a supporter of Hezbollah. To prove that he was using Green 023, the prosecution led evidence that Mr. Badreddin was also using 2 personal mobiles, number 663 and 354, that collocated with Green 023. It led extensive evidence of the use of these 2 mobiles. Mr. Badreddin was also using 5 other mobiles numbers used in sequential order, meaning that each phone was used for a period of weeks or months and then replaced by another. Some witnesses knew Mr. Badreddin under his alias of Sami Isa. He attended the Lebanese American University as a student between 1997 and 2004. He graduated in 2005 with a Bachelor of Arts in Political Science. From about 2002 to 2005, calling himself Sami Isa, he befriended students at the university and socialized with them. Sami Isa had bodyguards, one or more apartments in or near Jounieh, which is about 20 or so kilometers north of Beirut, a boat called Samino that he moored north of Beirut, and he owned a jewelry business, Samino Jewelry, that had 3 branches in Beirut. 10 witnesses identified his mobile number 354 and 663 as Sami Isa's. Text messages used the name Sami and Samino, quote unquote. Sami Isa, like Mustafa Badreddin, had a leg injury and walked with a limp. Text messages to both personal mobiles refer to his leg and foot injuries. The two also shared the same birthday, 6 April. Sami Isa traveled with armed bodyguards, used multiple mobiles, and took precautionary measures to avoid being photographed or leaving his fingerprints on objects. One mobile had 855 contacts with one of Mr. Badreddin's girlfriends and 128 with another. It also had 2,056 contacts with his sister's mobile and hundreds of contacts with the Samino outlets. Another had 21,372 contacts with one girlfriend and 3,151 with another. It had thousands of contacts with the Samino stores and its associates, as well 1,895 with an employee. The two mobiles had an overlapping geographical profile and use pattern and numerous common contacts. A third personal mobile had hundreds of contacts with the mobiles of Sami Isa's business partner at Samino and its registered owner. It had a smaller circle of contacts, including what were described as Samino insiders, quote-unquote, Hezbollah officials, and several Badreddin family members with a lower volume of traffic. In May 2016, when Hezbollah announced Mr. Badreddin's death in combat in Syria, it released biographical details, including photographs and video footage, and stated that he was a senior Hezbollah military commander. 8 witnesses recognized Mr. Badreddin as the person they knew as Sami Isa. The evidence that Mr. Badreddin was Sami Isa and was using the 3 personal mobiles is overwhelming. The cell site evidence established that mobiles 354 and 944 collocated, and that mobiles 944 and 663 collocated both had a single user. Green 023 was used on 57 days between 28 September 2004 and 12 February 2005. It moved consistently with the other 3 mobiles. The evidence established that Mr. Badreddin was using personal mobiles 354, 663, and 944 in the periods alleged, either under his own name or his alias Sami Isa. These mobiles collocated with Green 023, especially in their movements between the Jounieh area and southern Beirut, in such a manner that the only reasonable conclusion from the evidence is that Mr. Badreddin was also using that mobile and as its single user.
We will now take half an hour break. Court's adjourned.
We voulez-vous lever تفضلوا بالوقوف. All rise, voulez-vous lever تفضلوا بالوقوف. Please be seated. Vous asseoir تفضلوا بالجلوس.
Turning to the next section, which is the surveillance of Mr. Rafiq Hariri before his murder. In the months before Mr. Hariri's assassination, the blue, red and yellow networks, and specifically the 6 core red mobiles, the 6 core blue mobiles and the 4 core yellow mobiles, conducted observations and surveillance of Mr. Hariri and his movements. On 39 days between Wednesday the 20th of October 2004 and Monday the 14th of February 2005, there was significant network activity in the area of his home, Kuratum Palace. On 14 days between Thursday the 11th of November 2004 and Monday 14th of February 2005, network mobiles followed Mr. Hariri's security detail. This showed an unequivocal pattern of the network mobiles shadowing Mr. Hariri. On some of these days, and on others in the same period, network mobiles connected to cells providing coverage to locations relevant to Mr. Hariri, such as Kuratum Palace, for example. Some of the surveillance, especially in the weeks before Mr. Hariri's death, was clearly connected with the assassination. These network mobiles generally activated cells near Kuratum Palace when Mr. Hariri was present there. There is no direct evidence that the users of the network mobiles were engaged in surveillance of Mr. Hariri. The evidence is circumstantial, consisting only of call data and cell site records showing the cell activations that reveal the calling and cell siting patterns of the network mobiles, and then matching these with Mr. Hariri's provable known movements. When the two correspond, patterns emerge from which it can be concluded that the locations of network mobiles and Mr. Hariri coincided in a manner either that they were following or observing him or his security detail. As mentioned earlier, the red, blue and green networks operated completely covertly. Yellow network mobiles swapped handsets between the SIM cards, including between 3 blue network mobiles and on Mr. Ayyash's personal mobiles, 165 and 170. The blue mobiles operated as a covert network, and a core of 6 operated covertly from sometime in December 2004 until Monday, 14th of February 2005. They communicated almost exclusively with each other. The red network, apart from its surveillance activities, also had a crucial role in executing the attack on the 14th of February 2005. It was, as mentioned earlier and as the prosecution alleged, the assassination team or network. The red mobiles were active in the area of Kuratum Palace in the morning and then in the Parliament and crime scene area. They were indisputably involved in Mr. Hariri's assassination. In the last 2 hours before the attack, 33 calls were made between the 6 red mobiles. between 12:49 and 12:53. Mr. Ayyash's Red 741 and 5 other Red network mobiles were involved in the 7 final calls of this network. The explosion that killed Mr. Hariri and the others occurred at 12:55. These mobiles were never used again. There were, however, insufficient green network calls to allow the trial chamber to link them to pleaded events, which would have provided the necessary factual context. The green network had the appearance of a triangular framework with Mr. Merai's attributed green 071 and Mr. Ayyash's green 300, never calling each other but only communicating with Mr. Badreddin's green 023. However, insufficient evidence exists to conclude that the green network was the mission command, the apex of the operation, with Mr. Badreddin at its peak functioning as a, quote, mission command, unquote. The trial chamber was of the view that it was not the only reasonable conclusion available from the evidence that the green network acted as this mission command. The trial chamber allowed for the reasonable possibility that the green network had another function, one not necessarily at the apex of all the other networks. The trial chamber therefore cannot be satisfied beyond reasonable doubt that Mr. Badreddin masterminded the attack, as alleged. Some core users of the red, yellow, green and blue networks had a common mission, namely the assassination, that is the murder, of Mr. Hariri. The evidence is insufficient, however, to establish that all surveillance by network mobile users in the months preceding Mr. Hariri's death was a preparatory act for the assassination and hence was connected with it. Mr. Hariri was also under surveillance by others, including the Lebanese internal security forces. The only conclusion available from the totality of the evidence is that the network mobiles were engaged in surveillance of Mr. Hariri in the months prior to the attack, and that a portion of it was preparatory work for his assassination. The days of use of the green, blue and red networks largely overlapped, and between Friday the 14th of January and Monday the 14th of February 2005, the red mobiles were active on 11 days, the green mobiles on 21 days, and the blue mobiles on 31 days. It is clear from the patterns of cell activations and the sequences of some calls between network users that the 4 networks, that's red, green, blue and yellow, were interconnected and coordinated with each other. The prosecution proved both static and mobile surveillance of Mr. Hariri on a number of days. The cell masked activations of the mobiles used by Mr. Hariri's security detail prove his movements. His detail was always with him. Other evidence, such as photographs and media reporting, also corroborates Mr. Hariri's visits to various locations. Additionally, the trial chamber received ample evidence from his staff and palace documents, such as its visitors' logbook, and of media releases of his presence at Kuratum Palace and his absences from Beirut and Lebanon, to prove where Mr. Hariri was at all relevant times. This evidence effectively proves Mr. Hariri's movements between Wednesday 20th of October 2004 and Monday 14th of February 2005. The trial chamber has analysed both the static and mobile surveillance alleged. It has examined the evidence of each alleged incident, and in the light of the evidence of the networks and their connections. The ultimate issue is whether the various network cell activations and calls, in combination with Mr. Hariri's movements, leads to only one inevitable conclusion, namely that they were engaged in the surveillance or observations of him. The trial chamber is satisfied that this is what happened. The evidence establishes that on 39 days between Wednesday 20th of October 2004 and Monday 14th of February 2005, there was significant network activity in the area of Kuratum Palace. There was an unequivocal pattern of the networks shadowing Mr. Hariri. On a number of occasions between Thursday the 11th of November 2004 and Monday 14th of February 2005, it is obvious from the presence of network mobiles connecting to cells near where Mr. Hariri's security detail was that they had, quote, followed, unquote, him to where he was. One striking feature is that during Mr. Hariri's absences from Lebanon, network activity significantly scaled down and most ceased around Kuratum Palace. The patterns of calls between network mobiles, their presence connecting to cells around Kuratum Palace, the airport, and in the Furaya area, and in other places where Mr. Hariri was, such as his visits to churches, his dinners and lunches, is beyond coincidence. There are too many calls and too many instances of network mobiles sharing a locality with Mr. Hariri, and over an extended period, for this to be accidental. This happened too often and in too many different places to be spontaneous. The mobile users were communicating in closed networks, and on different days, their users operated in locations where Mr. Hariri was present. There was also static surveillance, and clear patterns emerged of network mobile presence near Kuratum Palace and along the route to Mr. Hariri's Fakra Villa near Furaya. Significantly, there was very little network activity around Kuratum Palace when Mr. Hariri was not there. The users of the blue, red and yellow networks, and more specifically the 6 core red mobiles, the 6 core blue mobiles and the 4 core yellow mobiles, conducted observations or surveillance of Mr. Hariri and his movements on different days from Wednesday the 20th of October 2004 to Monday the 14th of February 2005. The trial chamber is therefore satisfied that the only reasonable conclusion available from the evidence is that Mr. Hariri was under surveillance from Wednesday the 20th of October 2004 to Monday the 14th of February 2005, with the surveillance in the latter period connected with his possible assassination. But the trial chamber cannot find that all of it was connected with the plan to assassinate, that is, to murder Mr. Hariri. The evidence only suffices to establish that the final decision to assassinate Mr. Hariri was most probably made sometime in early February 2005. The trial chamber cannot, however, positively conclude that the surveillance in October, November, and December 2004 and January 2005 was solely for the purpose of planning his assassination, his murder. Undoubtedly, some of it in the latter part of January 2005 was directed at obtaining information about Mr. Hariri's movements and convoy, if needed, to continue with a plan to assassinate him, which had been hatched by then. At least some of the users of the red, yellow, green and blue networks had a common mission, namely the assassination of Mr. Hariri. However, the fact that these networks were connected and that their existence was linked to Mr. Hariri's movements and eventually his assassination does not mean that every user of every network mobile knew about the mission to assassinate him. That is, either in detail or at all. The next topic is the Canter, the Mitsubishi Canter. Two men purchased the Canter in cash in mid-January 2005 in Tripoli. Neither call data records nor the dealership's records can confirm the sale date. The prosecution argues that the truck was sold on the 25th of January 2005 and Mr. Ayyash coordinated its purchase. The preponderance of witness evidence supports that date, which is confirmed by the network activity. The Ayyash defence submits that 17th of January 2005 is the more likely date. Indeed, they say that cell coverage records prove it could not have been 25th of January 2005, and that the witnesses' conclusion about that date was unpersuasive given the methods by which they reached it. Furthermore, according to the Ayyash defence, Mr. Ayyash was in Saudi Arabia, not Lebanon, from 15th to 28th of January 2005. The trial chamber has concluded that 25th of January 2005 is the more likely date. There is, however, insufficient evidence to determine beyond reasonable doubt either any particular network mobile user's role in the Canter's purchase or what any of them did afterwards to prepare it for use in the attack on Mr. Hariri's life. Turning to the false claim of responsibility for the attack. In the immediate aftermath of the explosion on Monday the 14th of February 2005, Beirut was in a state of chaos and crisis. The trial chamber received evidence of an atmosphere of turmoil that included the overloading of the mobile networks and a breakdown in communications. People were desperately trying to obtain information about family and friends. The crime scene was swamped with emergency and security personnel, journalists, and many others who should not have been there, including people looking for their loved ones. It was at first unclear whether Mr. Hariri had survived the attack. When his death was announced, the obvious question was, who was responsible? It was in this setting, but before Mr. Hariri was officially confirmed dead, that the Beirut offices of Reuters and Al Jazeera received calls claiming responsibility for the attack. Some hours later, international media outlets then broadcast a claim of responsibility for the attack, in which a 22-year-old Palestinian, Mr. Ahmed Abu Adas, claimed responsibility for the attack on behalf of an unknown fundamentalist group called El-Nusra wal-Jihad fi Bilad el-Sham. In English, that's translated as Victory and Jihad in Greater Syria. Mr. Abu Adas's family had reported him missing a month earlier, on the 16th of January 2005. The prosecutor's case is that the claim of responsibility was false and that the fundamentalist group is fictional. Rather, that Mustafa, Badreddin, Mr. Merhai, Mr. Onesi and Mr. Sabra were responsible for manufacturing a false claim of responsibility to deflect attention away from the true perpetrators of the attack. Under Mr. Merhai's coordination, Mr. Onesi and Mr. Sabra are alleged to have participated in disseminating statements falsely attributing responsibility for the attack, ensuring the delivery of the video and a letter to Al Jazeera, and that the video would be broadcast. Their role in the claim of responsibility is the sole basis for Mr. Merhai, Mr. Onesi, and Mr. Sabra's alleged criminal responsibility. The core events of the false claim plot as alleged by the prosecutor were the following. First, the conspirators identifying a suitable person to make the false claim, namely Mr. Abu Adas, who was a young, introverted person with strong religious leanings in the Arab University Mosque in Beirut. Mr. Onesi allegedly befriended Mr. Abu Adas by pretending to be, quote, Muhammad, unquote, who needed assistance in learning to pray. Secondly, affecting the disappearance of Mr. Abu Adas from his home on Sunday, the 16th of January 2005, Muhammad, namely Mr. Onesi, also participated in this, according to the prosecutor. Thirdly, creating a video in which Mr. Abu Adas falsely claimed responsibility for the attack on Mr. Hariri. If I said fourth, I meant thirdly. And fourthly, disseminating and publishing the false claim via media outlets immediately after the assassination on Monday, the 14th of February 2005. The trial chamber heard evidence of what occurred in the mosque in January 2005 from Mr. Abu Adas's family, friends and associates, and of those who received and broadcast also of those who received and broadcast the video on the afternoon of Monday, the 14th of February. As noted earlier, the trial chamber was not convinced beyond reasonable doubt that Mr. Merai was using green 071, nor that Mr. Sabra was the sole user of purple 018. But to do justice to the prosecutor's case, the trial chamber has also analysed the evidence, but working on the assumption that Mr. Sabra was purple 018's single user. So even if the trial chamber is legally wrong about that, it has still nonetheless analysed whether, if they were using these mobiles, they could still be guilty. 4 calls were made to the news outlets Reuters and Al Jazeera in Beirut in the afternoon after the attack, from 4 different payphones and using the same telecard. These were 1 to Reuters at 14:11 and 3 to Al Jazeera at 14:19, 15:27 and 17:04. The Beirut Al Jazeera bureau chief, Mr. Hassan Benjeddo, took 3 calls relating to this. At around 14:19, someone called Al Jazeera's Beirut office. Mr. Benjeddo testified that the caller said something very similar to the written text containing the claim of responsibility for the assassination, which the Al Jazeera office received later that afternoon. The second call was at 15:27. The caller told Mr. Benjeddo that there was a videotape on a tree near the Al Jazeera building next to a pink building. He said that it must be retrieved within 15 minutes or it would not be found. A technician working at Al Jazeera then volunteered to go and get the tape. He walked around the tree 2 or 3 times before he noticed a white box on one of the branches. He climbed about a metre or a metre and a half up the tree and collected the box. A third call was made to Al Jazeera at 17:04. The caller became threatening and in a sharp voice said that Al Jazeera would hear a lot in the future about the group claiming responsibility for the attack, and that it was in the company's interest to cooperate. The video was broadcast on Al Jazeera at 17:30 that afternoon. The video tape contained a footage of Mr. Abu Adas, who was seated under a banner purportedly to be that of the group El-Nusra wal-Jihad fi Bilad el-Sham, reading out a claim of responsibility, stating the following: to to inflict just punishment upon the agent of that regime and its cheap tool in Greater Syria, the sinner and holder of ill-gotten gains, Rafiq Hariri, through the execution of a resounding martyrdom operation, such as to confirm our promise of victory and jihad and to herald numerous martyrdom operations against the infidels, apostates and tyrants in the Greater Syria. The letter accompanying the videotape stated that a suicide mission had been carried out what was described as the, quote, agent of infidelity in the land of the two holy places, unquote, meaning Mr. Rafiq Hariri and Saudi Arabia, and through a suicide operation carried out by Ahmed Abu Adas. And it said, quote, attached is a film of the martyr Ahmed Abu Adas who carried out the operation, unquote. The trial chamber cannot determine who made the calls, nor how many callers there were. Mr. Benjeddo testified that 3 different people called Al Jazeera regarding the claim of responsibility. It is also possible that another, different person called Reuters, although it is most likely that the same people made the calls. There is no way of comparing whether the same person or persons called both Reuters and Al Jazeera. The trial chamber also cannot determine when the package was placed in the tree. There is no evidence about whether it was placed there before or after the attack. Further, the 2 mobile telecommunications networks, Alpha and MTC Touch, suffered instability and congestion on the afternoon of Monday, 14th of February 2005 in Beirut, after the attack on Mr. Hariri, and especially in the area relatively near the crime scene. This affects the reliability of this evidence. The network congestion that afternoon means that Mr. Sabra's shared Purple Mobile and Mr. Onesi's personal Purple Mobile may not have been connecting to the best serving cell for any of the calls they made that afternoon. Theoretically, they could have been in the coverage area of any of the 6 neighbouring cells or cells adjacent to these when they made the calls. It is, of course, suspicious that the user of Purple 018 and Mr. Onesi as the user of Purple 095, or both, were relatively near the 4 payphones or the tree containing the video on Monday, 14th of February 2005. This, though, is in the qualified sense of there being at least within a few kilometres of them at relevant times, while recognising the possible patterns that emerge, and that this occurred within a comparatively short period around when the calls to Reuters and Al Jazeera were made and the video was collected. The strongest evidence is that the users of the 2 Purple mobiles were connecting to a cell providing coverage to a tree when the Al Jazeera employee collected that package, thus potentially allowing them to observe what was happening. However, the networks were congested at the time. The mobile users may have been somewhere nearby and not connecting to the cell providing this coverage, and therefore not within viewing distance of the tree. It is impossible to tell. The patterns of contacts between Purple 018 and Purple 095 and Purple 018 and Purple 231, that's Mr. Merai's mobile, also clearly attract suspicion. These mobiles were in contact with each other on Monday the 14th of February 2005 at times relatively close to the times of the telephone calls and the video collection. However, Mr. Benjeddo firmly stated that there were 3 distinct callers. he may well have been mistaken. It is of course possible that one person, disguising their voice, made all 3 calls. The caller or callers may not even have been male, but that is the evidence. So, however suspicious the Purple Mobile's movements and communications with each other on Monday the 14th of February 2005 and in the preceding weeks are, they are insufficient to establish Mr. Onesi's and Mr. Sabra's involvement in the claim of responsibility. There is too much uncertainty surrounding what they were doing. There is no evidence of the content of their calls, their texts, and whether they met or where and when and what was discussed. Nor does the evidence establish that Mr. Sabra was using Purple 018 that afternoon. The Purple Mobile activity highlighted by the prosecution is too remote in time and distance to demonstrate that the accused, that is Mr. Onesi and Mr. Sabra, were present at the payphones when the calls were made, were otherwise involved in the calls, or were located at the site of the video collection. Going back to the person in the video, the false claim plot centres on its subject, Mr. Ahmed Abu Adas. He was a young man, perhaps with an introverted personality, who in the period before his disappearance was becoming increasingly religious. He was attending the mosque near his home daily and had developed an interest in Islamic literature. Mr. Abu Adas also appears to have been disinterested in politics. These factors in the trial chamber's assessment could have made him susceptible to approaches from groups wishing to recruit young, vulnerable people to their religious causes. But he could not drive. This also reasonably excludes him as a suicide bomber. The evidence implicating Mr. Merai, Mr. Onesi and Mr. Sabra in participating in the activities relating to making the claim of responsibility on the prosecution's case must be considered in combination with the evidence of their alleged involvement in Mr. Abu Adas's disappearance in January 2005, including that of his alleged, quote, abduction, unquote. The evidence in this respect is completely circumstantial. The prosecutor alleged that in late December 2004 to early January 2005, Mr. Abu Adas was identified as a likely scapegoat for making the false claim. Mr. Onesi, the prosecutor pleaded, posing as Muhammad, approached people, including Mr. Abu Adas, at the Arab University Mosque in Beirut. The telecommunications evidence also placed Mr. Onesi and Mr. Sabra around the Arab University Mosque in the relevant period. The evidence of Mr. Abu Adas's possible encounters with anyone called Muhammad in the mosque in that period, that is in December 2004 and January 2005, is mostly hearsay, and in some cases comes from statements admitted into evidence of unavailable witnesses who did not testify and could not be cross-examined by the defence. This substantially diminishes their reliability. The thread running through all accounts is of Mr. Abu Adas teaching someone to pray in the mosque near his home in the weeks before his disappearance. But only one witness provided direct evidence of Mr. Abu Adas apparently teaching anyone to pray in the mosque. That witness saw Mr. Abu Adas with a young man in the mosque shortly before his disappearance. Now, Mr. Abu Adas disappeared on Sunday, the 16th of January 2005. He was teaching the young man how to pray. Another witness encountered a, quote, Muhammad, unquote, in the mosque at the beginning of January 2005, who said that he did not know how to pray and would like the witness to teach him how. The witness pointed at Mr. Abu Adas as someone who could and was better suited to teach this Muhammad how to pray. More than 5 years later, the witness tapped on Mr. Anesi's photograph on a photo board shown to the witness by prosecution investigators. However, the two witnesses do not necessarily correlate or corroborate each other. There is no certainty that they were referring to the same person and that it was the, quote, Muhammad, unquote, in question. The prosecution has therefore not established beyond a reasonable doubt that Mr. Abu Adas met a person called Muhammad at the mosque in late December 2004 or early January 2005 and taught him how to pray. Moreover, the purported identification evidence of Muhammad as Mr. Anesi was flawed and unreliable. There was a gap of more than 5 years between when the witness saw Muhammad in the Arab University Mosque in January 2005 and the purported identification of Mr. Anesi as this Muhammad to prosecution investigators in March 2010. The identification was also conducted in a flawed manner. An Anesi defence expert, whose evidence the trial chamber has accepted, testified about this. The trial chamber has therefore not relied on the identification evidence. Judge Noelsworthy will read the next portion.
Thank you. The prosecution's case alleging Mr. Onassis and Mr. Sabra's involvement in the Mohammed quote-unquote story and Mr. Abu Adas's disappearance and his subsequent appearance in the broadcast video hinges upon it proving their presence in and near the Arab University Mosque at the relevant times in late December 2004 and early January 2005. The allegation that Mr. Onasi befriended Mr. Abu Adas, pretending to be Mohammed and seeking assistance in learning how to pray, was central to this part of the case. To a large extent, the prosecution case theory of Mr. Merai's, Mr. Onassis, and Mr. Sabra's involvement in the plot to kill Mr. Hariri relied upon proof that Mr. Onasi was Mohammed as the linchpin for proving his and Mr. Sabra's involvement in the telephone calls to Al Jazeera and Reuters on the 14th of February 2005. The combination of this evidence, together with the Purple Mobile's activations on the afternoon of Monday, 14 February, might have allowed the trial chamber to draw the necessary inferences that they were responsible for making the calls to the news agencies. However, without the evidence of their pleaded participation in the Mohammed quote-unquote story, and by extension, Mr. Abu Adas's disappearance, their only connection to the conspiracy was Mr. Onassis' Purple 095s and Mr. Sabra's attributed Purple 018's presence at various times at locations near the payphones and the tree on the afternoon of the 14th of February 2005, and additionally, quote-unquote, near the Arab University Mosque in December 2004 and January 2005. So once the main evidence linking Mr. Onasi with Mohammed is eliminated from consideration, the prosecution's case against the three accused considerably weakens. Mr. Onasi's Purple 095 was, quote, in the vicinity, unquote, of the mosque on 5 days, in the sense of connecting to nearby cells. A witness described meeting a Mohammed in the mosque on one of the two of these days. The mobile purple 018 used by Mr. Sabra and his wife was also near, quote unquote, the mosque on 8 days in the same period. The trial chamber, however, cannot find that Mr. Abu Adas met a Mohammed, quote unquote, in the mosque. It has only concluded that a witness met someone named Mohammed there in early January 2005, that this person asked the witness to teach him how to pray, and the witness pointed at nearby Mr. Abu Adas as someone who was better suited to teach this Mohammed how to pray. There was no reliable evidence that Mr. Abu Adas actually did this. Mr. Onassis' mobile's presence in the vicinity, quote unquote, of the mosque on one of the two possible dates for the encounter is insufficient of itself to establish beyond a reasonable doubt that Mr. Onassis was the Mohammed. This is so even when considering it with the totality of the Purple Mobile's activity at the time. There was no evidence connecting calls between the three Purple Mobiles with anything related to Mr. Abu Adas, the mosque, anyone called Mohammed, Mr. Abu Adas' disappearance, the video or its making or its broadcast. And the last call between Green 071, attributed to Mr. Merai, and Mr. Badreddin on Green 023 was on Monday, 7th of February, 2005, in circumstances which appeared to the trial chamber to be devoid of context. There is also no reliable evidence connecting any of the three with Mr. Abu Adas's disappearance from his home on the morning of Sunday, 16 January 2005. The evidence that Mr. Abu Adas left home with Mohammed, quote unquote, is insufficiently reliable to find that this occurred. Mr. Abu Adas could equally have left with someone else or could have departed alone. The trial chamber cannot safely find that Mr. Abu Adas left with Mohammed on Sunday, 16 January 2005. On the morning of Sunday, 16 January 2005, Green 071 called Mr. Badreddin's Green 023 5 times. Despite this, there's no reliable evidence connecting Mr. Merai's calls on his attributed Green Network mobile to Mr. Badreddin that morning with the disappearance, notwithstanding the temporal coincidence with his disappearance that day. Therefore, the only conclusion reasonably available from the cell site evidence of the mobile activities is that the trial chamber cannot positively find that any of the three accused were involved in Mr. Abu Adas's disappearance on Sunday, 16th January 2005. The trial chamber cannot determine when the videotape was made, beyond the obvious that it was made after Mr. Abu Addas's disappearance on Sunday, 16 January, and before Mr. Herrera's assassination on Monday, 14 February 2005. There is no evidence connecting any of the accused with the making of the video, nor any of the other preparatory acts to making the claim of responsibility on Monday, 14 February 2005. The trial chamber, therefore, cannot conclude that the only inference reasonably available from the totality of the evidence is that any of the three accused were involved in making the video used in the false claim of responsibility for the attack. The heart of the prosecution's case against Mr. Merai, Mr. Onesi, and Mr. Sabra is that the claim of responsibility was false. The amended consolidated indictment avers that they participated in making a knowingly false claim of responsibility, and the prosecution's case proceeded on that basis. However, no direct evidence that it was a false claim of responsibility was produced at trial. There is also no direct evidence linking Mr. Abu Addas with the crime scene. The only evidence is his appearance on the video. The only evidence about the existence or otherwise of this group comes from Mr. Benjedo, who testified that it had not been heard of before or after the claim of responsibility. Mr. Abu Addas may have voluntarily joined a fictitious jihadi group, or perhaps thought that he had joined a real one and freely participated in a video claiming responsibility for an attack before it had occurred. Maybe he was lured into making the video for unknown reasons, or alternatively, he was forced to do so. The evidence is, however, insufficient to allow the trial chamber to draw any positive conclusions either way. The trial chamber is satisfied beyond a reasonable doubt that the claim of responsibility for the attack, as shown in the video, letter, and telephone calls to Reuters and Al Jazeera, was a false claim. The most likely explanation is that those responsible for Mr. Herrera's assassination attempted to turn attention away from themselves by diverting it to someone claiming hatred of Mr. Herrera based upon his connections with Saudi Arabia, ostensibly to avenge the deaths of those who Saudi security forces had killed. The trial chamber, however, cannot positively determine from the totality of the evidence whether Mr. Abu Addas was forced to participate in the making of the video, or alternatively, whether he did so voluntarily. Either is possible. Given that Mr. Abu Addas does not claim to be the suicide bomber, he could have been tricked into making and participating in the video. On the other hand, he could have agreed to do it without needing to have been duped. The content of the video itself does not permit the trial chamber to draw an inference one way or the other. The trial chamber also cannot make any explicit finding about Mr. Abu Adas's fate. He's most likely deceased, and most possibly from soon after his disappearance. However, there is no evidence on the record from which the trial chamber can make a definitive finding about what happened to him or when. Mr. Abu Adas was not the suicide bomber, and his disappearance is consistent with him being used to set up a false claim of responsibility for the attack by those who perpetrated it. The evidence also suggests that the group El-Nusra wal Jihad fi Bilad el-Sham was fictitious, meaning that both aspects of the false claim were indeed false. Further, even if the trial chamber's conclusion that Mr. Abu Adas was not the suicide bomber is incorrect, the findings of criminal responsibility against Mr. Merai, Mr. Onesi, and Mr. Sabra would not change. Whether or not Mr. Sabra was the suicide bomber, there is still insufficient evidence to prove beyond reasonable doubt their participation in the counts charged in the amended consolidated indictment. Mr. Merai, Mr. Onesi, and Mr. Sabra were, on the prosecution's case, using their personal mobiles to communicate, at least by mobile telephone, in executing the false claim of responsibility. However, 1 or 2 days after Mr. Herrera's assassination, they were all discarded. The coincidental cessation in the use of the purple mobiles after several years of active use may indeed suggest that this decision came after a certain event and due to some fear. However, such a decision in the context of an alleged conspiracy whose participants otherwise used a covert network seems contradictory and, in the trial chamber's view, difficult to explain. However, ultimately, it is not the only reasonable inference available from the evidence. Another is that they were not involved in the alleged criminal activity, or that they were not previously aware of the scope and significance of their call activity. Otherwise, they would not have used their personal mobiles to carry it out. The prosecutor relied on this strand of evidence to buttress a circumstantial case regarding mobile usage. The discarding of the mobiles was used to help prove that the 3 accused were involved in making the false claim of responsibility. Conversely, the mobile activities on Monday, 14 February 2005, were used to prove that something occurred that required the 3 to discard their mobiles over the next few days. That is, that they had a criminal reason to do so. In other words, the 2 strands of evidence must be taken together. Hence, even if the trial chamber is wrong in not finding that the only inference reasonably available from the evidence is that the discarding of the mobiles soon after the attack means that they were involved in the attack, this only has context when considered with all the other cell site evidence. But as the trial chamber cannot be convinced beyond reasonable doubt that the mobile's activities on the afternoon of 14 February only equated to participation in the false claim of responsibility, then discarding these mobiles within the next 2 days cannot persuade the trial chamber that the prosecutor has proved that they were used in the false claim. The prosecution has therefore not proved its case beyond reasonable doubt of Mr. Merai's, Mr. Onassis, and Mr. Sabra's participation in the false claim of responsibility for the attack on Mr. Hariri. The trial chamber will now move to committing a terrorist act by means of an explosive device. The explosion on the 14th of February 2005 was a terrorist act within the meaning of Article 314 of the Lebanese Criminal Code, committed by means liable to create a public danger, such as explosive devices. Detonating an explosive device, in inverted commas, of 2,500 to 3,000 kilograms of TNT, equivalent high explosives, set on the back of a light truck, falls squarely within Article 314 as one committed by means liable to create a public danger. This particular device was of such a powerful explosive RDX and so large that it was inevitably going to kill or injure numerous people who were nearby when it exploded. Detonating a device of that magnitude, likewise, was inevitably going to destroy or damage proximate buildings and vehicles and ignite fires. The explosion endangered anyone and any nearby property without doubt. The device exploded in a busy city street in the middle of a weekday. It was detonated approximately 50 to 80 meters above ground level. I beg your pardon. It was detonated approximately 50 to 80 centimeters above ground level in a street lined by multi-story buildings. This created a, quote, canyon effect, unquote, that increased its destructive powers. Numerous members of the public were bound to have been inside buildings or passing by, in vehicles or on foot, and within the explosion's range, regardless of the fact that the target was in fact Mr. Rafik Hariri. And hundreds were, as is shown by the proportion of those killed and injured, who were not members of Mr. Hariri's convoy. More than half of the 22 killed by the explosion, other than the suicide bomber, and almost all of the 226 others who were injured had no connection with Mr. Hariri's convoy. The explosion was an act intended to cause a state of terror. The size and power of the explosive device, the manner, the time, and the place of its detonation and its intended target prove this fact. Detonating the device in those circumstances obviously had the potential to cause fear and panic among at least members of the public in the area of the detonation. Anyone knowing that the attack was to be committed in this manner must have foreseen these consequences. The fact that a suicide bomber targeted Mr. Hariri also shows that the explosion was intended to cause a state of terror. It was foreseeable that the public would learn that a suicide bomber triggered the attack and that this too would frighten and horrify them. Indeed, the video featuring Mr. Abu Adas expressly claimed that a suicide bomber had triggered the explosion. Mr. Hariri was a former Prime Minister of Lebanon and a prominent political figure who, at the time of his death, was preparing for parliamentary elections in May 2005. His murder or attempted murder in a huge explosion would attract enormous publicity and cause many Lebanese to experience fear, insecurity, and loss. The evidence from participating victims and witnesses proves that this in reality occurred. Anyone who knew that the explosion was to be triggered in the street when Mr. Hariri's convoy was passing must have foreseen that numerous people would be killed or injured, regardless of whether it succeeded in killing him, Mr. Hariri. The state of terror was not just intended for the immediate area of the attack. The attack was intended to resonate throughout Lebanon and in the region. And its intended effects were not just confined to Mr. Hariri's supporters. Rather, the evidence of the political background to the attack demonstrates that it was designed to destabilize Lebanon generally. The explosive device triggered that day, both in itself and in the circumstances of its detonation, was likely to kill multiple people when detonated. With so large a group affected, the reasons why the injured did not die were unlikely to be the same for each person. Medical treatment after the attack would likely have saved some people's lives. Others may have avoided serious injury in the first place by virtue of where they were at the moment of the blast. The trial chamber is satisfied on the evidence before it that these, as well as a range of other circumstances, prevented the death of the 2,026 injured. I know. 226. You said 2,000. 226 injured, that should have been. Judge Brady may follow.
The trial chamber now turns to the conspiracy to commit a terrorist act. The 4 accused are charged with participating in a conspiracy in which they, together with Mustafa Amin Badreddin and other as yet unidentified, including the assassination team, agreed to commit a terrorist act by means of an explosive device in order to assassinate Mr. Hariri. Mr. Ayyash, Mr. Badreddin, and Mr. Merei are alleged to have been in the conspiracy between Thursday, 11 November 2004 and Monday, 14 February 2005, while Mr. Onaisi and Mr. Sabra are alleged to have joined the conspiracy between Wednesday, 22 December 2004 and Monday, 14 February 2005. The evidence does not establish either Mr. Onaisi or Mr. Sabra's participation in the conspiracy. So, this only concerns the roles of Mr. Ayyash, Mr. Badreddin, and Mr. Murray. To assassinate someone as closely guarded and protected as Mr. Hariri required much careful planning and preparation in the context of this case. This included obtaining a detailed knowledge of his movements, his convoy, its personnel, and his usual position within it, establishing closed mobile networks for communication between those having some role in the plot, knowing or otherwise, choosing a method of assassination, obtaining the Mitsubishi Canter, the vehicle used for the assassination, picking a suitable site for an explosion, selecting a manner of detonation, including recruiting the suicide bomber, procuring the explosives, and setting up the claim of responsibility, including arranging Mr. Abu Ada's role in it. Not everyone in the plot needed to know that they were part of a conspiracy that involved killing Mr. Hariri. At least some users of the green, red, blue, and yellow mobile networks had the common aim of assassinating Mr. Hariri, but others may not have. A number appear to have been involved in the essential preparatory work, but the number who had to have known of the objective of the plot, namely to kill Mr. Hariri of necessity, would have been smaller. The trial chamber has found that there was an agreement between two or more people to commit a terrorist act by means of an explosive device in order to assassinate Mr. Hariri. Many people were involved in the preparatory steps, with numerous different mobile users having conducted surveillance, for instance. The trial chamber cannot establish how many knowing participants there were in the overall conspiracy. Some, but not all of these people, needed to know that the conspiracy to commit a terrorist act had Mr. Hariri as its target. Those involved in the surveillance of Mr. Hariri's movements in December 2004 and January and February 2005 must have known that he and his convoy were the targets of the surveillance. The user of every core red, blue, and yellow mobile, including Mr. Ayyash, who conducted surveillance of Mr. Hariri and his movements, would have known that Mr. Hariri was the person under watch, although they did not need to know the precise reason why they had to have been trusted associates. This could have been through common membership in an organization. The 6 core red mobile users must have known who they were tracking on the day of the attack, both from their actions that day and their role in the surveillance leading to it. As for the claim of responsibility, anyone who was aware of the content of the videotape or its accompanying letter before the attack necessarily knew that Mr. Hariri was the intended victim of martyrdom. the term used in the video of the claim of responsibility, or a suicide operation. But knowledge of this fact alone does not necessarily extend to awareness that Mr. Hariri was going to die in a terrorist attack using an explosive device, as opposed to another manner of attack, for example, by shooting him in a public place. And the video does not mention how Mr. Hariri was to die nor when. Whoever triggered the explosive device that was on the counter knew that they were detonating an explosive device in a public location in a manner intended to spread terror and that it would kill and injure people. They must have known that they were going to detonate the explosives when Mr. Hariri's convoy passed and that it was the target of the attack. The driver of the canter was required to move towards Mr. Hariri's convoy as it passed the St. George Hotel and to detonate the explosives. After eliminating other possibilities as not reasonably available on the evidence, the trial chamber has concluded beyond reasonable doubt that the suicide bomber himself detonated the explosives. The suicide bomber, therefore, at least legally, was a member of the conspiracy. And as his body was not identified, his identity remains unknown. The evidence does not establish that the two men who bought the canter in Tripoli in mid-January 2005 knew that it was intended to be used in attack on Mr. Hariri, or that it was to be loaded with RDX or other explosives and used in the attack in that way. There is no evidence of mobile use directly connecting Mr. Ayyash or any other accused person with its purchase. It is possible that whoever purchased the counter, or at least one of the two, either knew of or participated in placing the RDX on it. On the other hand, it is equally conceivable that they did not. The canter, however, was not sold to the two buyers until either Monday 17 or Tuesday 25 January 2005. Mr. Ayyash Green Mobile was in Tripoli on 11 January. He may have been there looking around for a suitable vehicle to use it in the attack, but he may have been there for some other reason. Logically, those involved in the plot to kill Mr. Hariri would have participated in some way in the canter's purchase and employed a certain discipline while doing so. They most probably selected this particular truck yard in Tripoli because it sold trucks for cash with little documentation and without verifying buyers' identities. Its location in Tripoli also, as the prosecution contends, moved the purchaser away from Beirut, where the explosion was to occur. Nevertheless, those who actually bought the canter did not need to have been aware of the objective of the conspiracy. The conspiracy could have been tight, restricted to a handful of participants, or alternatively, one with a broader but still restricted membership, possibly limited to the 10 or so suggested by the prosecution. In this second scenario, the participants had varying roles, but each part was sufficiently important to the plan's success that before the attack on 14 February 2005, each of them knew its essential elements. That is, not just that their operation focused on Mr. Hariri, but also that the aim was to kill him and how this was to be done. The members of such a conspiracy would have included some or all of those who executed the terrorist attack, including the 6 core Red mobile users on 14 February 2005 and, at least legally, the suicide bomber. They may also have included the 2 men who purchased the canter and the person or persons who loaded the explosives onto it. In addition, such a conspiracy could also have included those who pursued or directed others to do the acts needed to prepare for and execute the attack, even if they did not themselves participate directly in any of those acts, and those who prepared the false claim of responsibility for the attack. The dissemination of the claim of responsibility was clearly meant to divert attention away from the attackers and to avoid detection and apprehension, but the conspirators may also have intended to foster a state of terror by broadcasting a claim by an unknown, fictitious militant group. Preparing the false claim involved committing serious criminal acts, including the possible abduction and murder of Mr. Abu Adas, who disappeared in mid-January 2005. The planning and propagating the claim of responsibility, including preparing Mr. Abu Adas for the video and then filming him, required strict secrecy and particular skills. Evidently, at least one person who participated in it knew of its connection with Mr. Hariri's intended assassination before it occurred. The video, however, does not say how Mr. Hariri was to be murdered. There is no mention of an explosion. Whoever made the video must have known of its connection with Mr. Hariri's intended death. Logic dictates that more than one person would have been involved in making the video and preparing Mr. Abu Adas for his role in it. However, there is no evidence of when this occurred. The video must have been made between Sunday, 16 January 2005, when Mr. Abu Adas left his home, and the time when the attack occurred on Monday, 14 February 2005. But exactly when is a matter of speculation, as nothing connects any of the accused with anything related to making the video, including when, where, and how it was made. Apart from the 6 core Red mobile users, the suicide bomber, those who purchased the canter or loaded the explosives, those who prepared the false claim, and those who directed them, unknown others may have helped to prepare the attack and legally participated in the conspiracy. An alternative inference, namely that only a much smaller subset had the necessary knowledge to be conspirators, is also available on the evidence. The conspiracy plausibly could have comprised only those who definitely had to know the assassination's operations aim in order to fulfill their role in it. Thus, it is equally conceivable that the conspirators deliberately kept that aim secret from as many people involved as possible by doing key tasks such as assembling the explosive device themselves or restricting the information flow between their operatives, or both. The network's hierarchical and compartmentalized communication structure would have facilitated this. If membership of the conspiracy was on a need-to-know, quote-unquote, basis, this eliminates several potential conspirators. First, someone tasked only with conducting surveillance before the day of the attack did not need to know that its objective was to murder Mr. Hariri. Indeed, this may not have been the sole purpose of much of the surveillance. The trial chamber could therefore not conclude that all of those involved in the surveillance were knowingly participating in the conspiracy alleged. Rather, because of Mr. Hariri's status and the prevailing political environment, they could reasonably have thought they were just engaged in a routine monitoring of his movements. The evidence that Mr. Hariri thought that he was under surveillance also supports this possible inference. His security detail certainly believed this and must have factored this into the measures they adopted to protect him in the months before his death. Naturally, whoever who engaged in the surveillance would have had to have been trusted enough not to have revealed their roles in the enterprise, which would have become evident after the attack. In other words, anyone who had been involved in the surveillance of Mr. Hariri before 14 February 2005, using mobiles that they were instructed either to discard or to return to someone afterwards for collection, would have realized, at least after the explosion, that their surveillance activities were connected with the attack. Only trusted associates could have been assigned such a task. But this does not mean that all of them must also have been entrusted before the attack with the information that it would happen, nor how, nor when, nor they agreed to commit it. Similarly, while those whose role was confined to preparing either the claim of responsibility or the explosive device, if there were any such people, may have been fully aware of the conspiracy's aim, the evidence does not establish that they had to be. Rather, it is also reasonably conceivable that someone involved in the plot met Mr. Abu Adas in the Arab University Mosque and lured him from his home, but did not know that these actions were connected with Mr. Hariri's intended assassination, nor that he was to be killed specifically by a large explosive device. The trial chamber received no evidence from which it could conclude when, where, and how the explosives came to be on the counter. The evidence can only establish that it must have been between Monday 17 January and Monday 14 February 2005. For operational security and safety reasons, it can probably safely be assumed that the explosives were loaded onto the light truck only after firm decisions had been made to use the canter and when. Moreover, whoever put the explosives on the canter did not have to have known why, namely, that a suicide bomber was to drive it into Mr. Hariri's convoy, nor even that it was to be detonated in a public place. Placing explosives on a truck and their detonation at a later point are not necessarily connected activities, especially as it is unknown when the explosives were put on the canter. However, it is far more likely that whoever did this was involved in the conspiracy. It was a core activity in the conspiracy. And of necessity, such an action should have been restricted to those as on the plot. This is for the obvious reason that once the explosion occurred, anyone who had unknowingly assisted would have realized what they have done, thus potentially compromising the secrecy of the operation. However, a trusted operative could have been tasked with putting the explosives on the canter without being informed of precisely why, but nonetheless still sufficiently trusted not to reveal this afterwards. The explosives would have had a volume of a minimum of 1.3 cubic meters and weight close to 2 tons. The mere fact of placing or loading this quantity of RDX onto the canter would have been inherently suspicious. This 2 points to the involvement in the conspiracy of people with a commonality such a membership of an organization, namely a tight-knit organization in which trusted operatives are delegated particular sensitive tasks. The trial chamber, therefore, believes that the most logical inference available from the evidence is that whoever put the explosives on the canter was either part of the conspiracy or was trusted enough not to reveal their role in it. But it cannot be satisfied which, if either occurred. It simply has no direct evidence, one way or another, as to what occurred. Additionally, there is no circumstantial evidence from which it could draw an inference establishing how the RDX came to be on the canter or who put it there. Whether the conspiracy was thus restricted to 2 or was larger, its members might have decided together to assassinate Mr. Hariri in a large explosion in a public place before the red, blue, and yellow mobiles surveillance or any other preparation began. However, the conspirators may also have reached that decision later, perhaps as late as mid-January 2005, which is the earliest time on the evidence when the canter could have begun to have been fitted for the attack. Alternatively, if it were a larger conspiracy, some members, such as some of the red mobile users, may have joined that conspiracy well after it was formed, possibly even learning the full or real objective only on the morning of the attack. All of these scenarios are possible on the evidence, and any of them would fulfill the definition of a conspiracy, namely an agreement to commit the pleaded crime. The assassination of the former Lebanese prime minister did not occur in a vacuum, nor was it organized by the 6 core users of the Red Network. The political and background evidence points to it being a political act directed by those whose activities Mr. Hariri's were threatening. There is no evidence that Mr. Ayyash or the other 5 core Red users fell into this category. The evidence is of their involvement in the conspiracy at least on 14 February 2005 and the immediate period leading to it. But the evidence does not establish affirmatively who directed them to murder Mr. Hariri and thus eliminate him as a political opponent.
To Mr. Salim Jamil Ayyash. The evidence connecting Mr. Ayyash with the attack on Mr. Hariri stems from his use of mobile Red 741. Without this, there will be no evidence linking him with the explosion on 14th of February 2005. He did not detonate the explosive with his own hands. The Red Network was the assassination team, as we have said. It was a closed network that ceased operation immediately before the attack after its use in the previous month in the surveillance of Mr. Hariri and the convoy's movements. It operated extensively on the day of the attack. Red Network mobile users were near or in the area of Kuratum Palace just after Mr. Hariri had left for the Parliament, and were active in monitoring him at the Parliament when he was in the Parliament area. They must also have assisted in preparing the counter for the attack at the crime scene. The trial chamber agrees with the prosecution's description in the Red Network in the indictment and the final trial brief as the assassination team. The only reasonable conclusion available from the evidence is that on Monday 14th of February 2005, the Red mobiles tracked the movement of Mr. Hariri and his convoy, alerted the others involved of his location, and prepared for surveillance and for the execution of the attack along the route that he was expected to take. This must have also aimed at ensuring that the explosive detonated at the exact time the convoy would pass. The users of the Red mobiles had prepared the attack through repeated operations of surveillance and reconnaissance in previous days. Mr. Ayyash, as the user of Red 741, Blue 233 and Green 300, must have been a core member of the conspiracy. Subject 6 using Red 678 and Blue 610 was also a conspirator. Overall, by virtue of their activities on 14th of February 2005 and their surveillance of Mr. Hariri in the preceding weeks, the trial chamber is also convinced that the 6 core Red Mobile users had the role that the prosecution alleged of an assassination team. They all knowingly agreed to murder Mr. Hariri using an explosive device. They are thus conspirators. Even if the conspiracy was kept deliberately tight, the users of the 6 core Red Mobiles were participants. Some of those mobiles made significantly more calls than others did on the 14th of February. All 6 played a crucial role in executing the attack. The evidence also suggests that each Red Mobile user also knew beforehand that the aim behind their tracking of Mr. Hariri that day was his murder using an explosive device in a public place. Besides the time and places that day at which they made and received calls, it is particularly relevant that every core Red Mobile user then stopped using that mobile forever shortly before the attack. It is improbable that all of them would do this if some of them did not know that the attack was going to happen. Mobile user in any of the covert networks who had a supervision role, someone who not only reported on developments but also coordinated, directed, and or supervised others, must have known about the mission, more about the mission than the users under their direction. The more extensive the contact that user had with other network mobile users and with the acts needed to prepare for and then execute the terrorist attack to kill Mr. Hariri, the more likely that they would know that the mission's overall aim was that attack. Mr. Ayyash's Red 741 fits this profile. That mobile's call activity in the hours before the attack on the 14th of February 2005 in itself makes it inconceivable that its user did not know the aim of the conspiracy by then. Red 741's calls to 3 other core Red mobiles that morning triggered their users' relocation to the Parliament area, and by doing so launched the beginning of the operation. The trial chamber is satisfied that this is the only reasonable inference available from the evidence. This evidence also supports the inference that Red 741's user coordinated at least some of the acts that executed the attack. Red 741's contact within the Red network on the day of the attack was also uniquely extensive. Only Red 741 had calls with every other core Red mobile. Moreover, on 4 different days before 14th of February, Red 741 had had calls with various other Red mobile users at the same time that they were conducting mobile surveillance. The trial chamber, for these and other reasons, is therefore convinced beyond reasonable doubt of Mr. Ayyash's participation in the conspiracy alleged. It is the only reasonable inference available from the totality of the evidence. Regarding the date of the commencement of the conspiracy, it is not possible to find a definitive date on which those responsible for organising the conspiracy agreed that Mr. Hariri was to be assassinated. They may have initially formed the intention to murder him in late 2004, given the volatile political environment and events at the time, following President Lahoud's mandate extension. Among other political developments that the trial chamber has described by that time, where the first 2 Bristol group meetings had occurred on 22nd of September and 13th of December 2004. Mr. Hariri was then planning to run for office again and was known to wish to loosen Syrian dominance over Lebanon. Factually, the following demonstrates that the planning for a possible attack on Mr. Hariri must have started from at least mid-January 2005. The Red Network handsets and SIM cards were purchased in Tripoli in late December 2004, early January 2005, and were initialized on 4th of January. The Red Network, the assassination team of which Mr. Ayyash was a member, began surveillance of Mr. Hariri's movements from Friday 14th of January and continued doing so until his death. Mr. Abu Adas disappeared on Sunday 16th of January, and the video was made between then and the attack. The canter was purchased on either 17 or 25 January, but most probably on 25 January. It is highly probable that those responsible for organising Mr. Hariri's assassination decided to murder him only if he continued on his foreshadowed political path away from Syria, and had commenced their preparations for this by at least January 2005. Assassinating the former and probable future Prime Minister was an act that those responsible must have known would have had significant regional and international consequences. They could only have decided to go through with it after having made a careful cost-benefit analysis in which they judged that the advantages of eliminating Mr. Hariri would significantly outweigh the disadvantages. Despite these preparatory steps, none, either individually or collectively, inevitably led to Mr. Hariri's assassination. The video could have been made and never used, as Mr. Abu Adas was clearly dispensable. The canter could have been purchased and then used for some other purpose, or sold, and the information gained from the surveillance could have been stored for future use. The intended possible attack could have been aborted at any time. It is most likely that those responsible were prepared either way, namely, to continue the attack if necessary, or to call it off. This decision to kill Mr. Hariri, and in an enormous explosion in a public place, would not have been taken lightly. Mr. Hariri had numerous powerful regional and international allies and connections, including in the United States, France, Saudi Arabia, and United Nations officials. It is thus highly likely that the decision to give the go-ahead only occurred in February 2005, after the third Bristol Group meeting on Wednesday the 2nd of February 2005. Mr. Hariri had sent his delegates to the meeting. It was at this third meeting that its participants had agreed to call for the immediate and total withdrawal of Syrian forces from Lebanon, a position that Mr. Hariri, according to his confidants, had by then adopted. They had also called for the dismantling of the Syrian security apparatus in Lebanon, with Mr. Hariri's tacit support. And significantly, the meeting had occurred the day after the Syrian Deputy Foreign Minister, Mr. Walid El-Mualim, visited Mr. Hariri at his home for the final time on Tuesday, 1st of February 2005. The transcript of its audio recording reveals that Mr. Hariri had told Mr. El-Mualim that, quote, Lebanon will not be ruled by Syria forever, unquote, as it was, quote, unacceptable, unquote, and that he could, quote, bear no more orders, unquote, from Syria, and that, quote, 3/4 of me is already on the opposition side, unquote, and that there was, quote, interference in every small detail in the country, unquote, referring to Lebanon. Despite Mr. El-Mwalim's approach to Mr. Hariri, the Bristol Group's public statement reported on Thursday, 3rd of February 2005, went further in relation to Syria's involvement in Lebanon than in its previous statements. A significant cross-section of the Lebanese political class was by then publicly advocating the full implementation of the 1989 end of civil war Taif Agreement and Syria's political, security and military redeployment from Lebanon. The trial chamber is therefore satisfied, based on the confluence of these events, that the final decision to commit the terrorist act was made only in the 2 weeks preceding Mr. Hariri's death. This is the only inference reasonably available from the evidence. Because of his role in the conspiracy, Mr. Ayyash, as the user of red 741, blue 233, and green 300, must have known its aim, whether conditional or final, for some time before the attack. This was most likely by mid to late January 2005 at the latest, on the basis that the canter was most probably purchased on 25 January, and preparations for its use in the attack could have begun. From the available evidence, however, the trial chamber cannot determine whether Mr. Ayyash, as the user of red 741, blue 233 and green 300, did anything in relation to either the false claim of responsibility or the preparation of the canter and the explosive device. In any event, it need not do this in order to determine his criminal responsibility. For the purposes of Mr. Ayyash's criminal responsibility, it is legally sufficient for the trial chamber to find that the evidence establishes beyond reasonable doubt that he agreed to commit the crimes charged by the day of the attack, namely Monday, 14th of February 2005. The trial chamber therefore finds that Mr. Ayyash was a member of the conspiracy in having agreed to commit the terrorist act charge from at least sometime in early February and at the very latest by Monday, 14th of February 2005. It is satisfied that this is the only inference reasonably available from the totality of the evidence. The trial chamber is therefore satisfied beyond reasonable doubt that Mr. Ayyash possessed the requisite knowledge that the explosive device was liable to create a public danger. That is also the only conclusion that is reasonably available from the evidence. The same evidence establishes beyond reasonable doubt his knowledge and his intention to murder Mr. Hariri with explosive materials. The trial chamber therefore finds Mr. Ayyash guilty beyond reasonable doubt as a co-perpetrator of the intentional homicide of Mr. Rafik Hariri. The same evidence also establishes beyond reasonable doubt his knowledge and his intention to commit the intentional homicide of 21 other people and the attempted intentional homicide of the 226 others. Mr. Ayyash intended to kill the members of Mr. Hariri's convoy and the members of the public who died in or as a result of the explosion or who were injured in the attack. Or legally, alternatively, he at least foresaw that deaths would occur and accepted that risk. The trial chamber also finds, in respect of the 226 people injured in the attack, that their death was prevented solely by circumstances beyond the perpetrator's control. There is no other conclusion reasonably available from the evidence. Detonating a truckload of explosives in a busy street near occupied buildings will inevitably kill many people. Some may die, some may not die, but instead sustain injury. Some injuries will be severe. However, whether or not these people die from their injuries, the act of participating in the detonation of the explosion was an act likely to cause death. In this respect, the conduct amounted to an attempted intentional homicide with premeditation by using explosive materials. Although Mr. Ayyash did not act alone, he had an important role in the operation against Mr. Hariri. The trial chamber is therefore satisfied beyond reasonable doubt that the prosecution has proved the guilt of Salim Jamil Ayyash on all counts charged in the amended consolidated indictment. Turning to Hussein Hassan Onesi and Assad Hassan Sabra. Mr. Sabra's attributed mobile, Purple 018, and Mr. Onesi, using his personal mobile, Purple 095, called each other and Mr. Merai on Purple 231 during the relevant pleaded period. Their mobiles were near areas where some false claim-related activities took place, such as the Arab University Mosque in late December 2004 and early January 2005. The two personal mobiles were used near relevant payphones on 14th of February 2005, and the tree from which the video was collected. Their personal mobiles stopped use shortly before the attack. This conduct, however, is insufficient either to prove conduct that assisted the perpetrator's preparation for the attack or that helped to shield the perpetrators or accomplices from justice. Their actions in Mr. Onesi being in these locations and Mr. Sabra's shared personal mobile, Purple 018, also being there, therefore do not satisfy legally the actus reus. That's the actions necessary to prove accomplice liability. The prosecution has also failed to establish the mental element of accomplice liability for either accused. Using or not using a mobile, calling each other and being somewhere in the area of locations where false claim-related activities took place cannot demonstrate beyond a reasonable doubt that they knew and accepted that the perpetrators would carry out an attack using an explosive device that was likely to kill people and to spread terror. This is said, it is emphasised, on the assumption that Mr. Sabra was using his attributed mobile at all relevant times. Even if it was proved that they did participate in calling the news agencies after the attack on 14th of February 2005, the trial chamber cannot conclude beyond reasonable doubt that the two were aware in advance of the attack, which occurred at around 12:55, that calling Al Jazeera and Reuters later that afternoon was connected with the attack. This is an essential legal requirement as an accessory under the Lebanese Criminal Code. The trial chamber accepts that if they indeed participated in making the calls to either news outlet, by virtue of the content of the letter that was read during the call, they would have known then, at that point, that their actions were connected with the attack. However, this would not of itself prove their knowledge of this before the attack, as is required for criminal liability as an accomplice under the Lebanese Criminal Code. The trial chamber's conclusion as to the lack of evidence that Mr. Onesi or Mr. Sabra participated in the, quote, Muhammad deceit, unquote, the, quote, abduction, unquote, of Mr. Abu Adas or the dissemination of the false claim therefore precludes their liability as accomplices. The trial chamber therefore finds that Mr. Onesi's and Mr. Sabra's liability as accomplices for the crimes charged has not been proven beyond a reasonable doubt. The trial chamber's determination that the prosecution failed to prove the two accused took part in the false claim is fatal to the charge of conspiracy against them. The trial chamber therefore finds that Mr. Onesi and Mr. Sabra cannot be found responsible for conspiracy to commit a terrorist act as charged in count 1 on the indictment. Turning to Mr. Hassan Habib Mehi. Mr. Mehi's sole pleaded role in the conspiracy is as the coordinator of the false claim of responsibility. This depends upon Mr. Onesi and Mr. Sabra acting as charged. Concerning the conspiracy and the alleged calls to and from Mr. Badreddin in the Green Network, and in particular Mr. Abu Adas's disappearance, the only reliable evidence supporting it is of mobile calls between the 3 purple mobiles over 2 separate periods. And both aspects come solely from the call data records of 2 mobiles in 2004 and 2005, namely his personal mobile Purple 231 and the Green Network mobile 071. There is no reliable evidence of anything relevant to the case regarding the making of the claim of responsibility, including its preparatory activities involving Mr. Abu Adas occurring on these days. Without these connections, the calls between Mr. Badreddin's Green 023 and Green 071 lack context. There is, it is emphasized, no evidence of what was said in the calls or any meetings between the users of the Green Network mobiles. There is no context from which the trial chamber can determine why the calls were made. It has insufficient evidence to connect these calls to Mr. Abu Adas's disappearance. When the evidence regarding Muhammad, in inverted commas, goes, all that remains are the calls between Mr. Mehi and Mr. Onesi and Mr. Sabra's shared mobiles in the weeks before Mr. Abu Adas's disappearance. Of itself, no matter how holistically the evidence is viewed, this cannot provide sufficient proof of their involvement in Mr. Abu Adas's disappearance, and certainly not for the pleaded purpose, namely of finding someone suitable to make a false claim of responsibility. Mr. Mehi's sole role in the conspiracy is connected with the false claim of responsibility and coordinating Mr. Onesi and Mr. Sabra. As the trial chamber is not satisfied beyond reasonable doubt that the pair did any of the pleaded activities, namely those connected with Mr. Abu Adas's alleged grooming, luring, disappearance, alleged, quote, abduction, unquote, and subsequent appearance on the broadcast video, it likewise follows that Mr. Mehi cannot be found guilty of coordinating these activities. Mr. Mehi allegedly coordinated with Mr. Badreddin the preparation of the false claim of responsibility. He allegedly coordinated the activities of Mr. Onesi and Mr. Sabra in the lead-up and aftermath of the attack. But the trial chamber cannot find beyond reasonable doubt that Mr. Mechai was using green 071. And even if he were, there was no reliable evidence providing context to the calls with Mr. Badreddin's mobile green 023. The trial chamber cannot link Mr. Onesi and Mr. Sabra to the false claim of responsibility. Accordingly, the link between Mr. Mechai and the false claim of responsibility is missing. He must be acquitted. Turning to whether Mr. Mustafa Amin Badreddin had a role in the conspiracy. To connect Mr. Badreddin to the conspiracy to commit the terrorist act and to murder Mr. Hariri, the trial chamber must be satisfied beyond reasonable doubt that the only reasonable conclusion available from the evidence is that Mr. Badreddin had the intention and performed the necessary acts to commit the crimes charged. This is not a finding of Mr. Badreddin's guilt beyond reasonable doubt, as he is no longer an accused person. The trial chamber cannot find that the Green Network operated as a command mission network with Mr. Badreddin at its peak. In other words, that he was the main conspirator. The trial chamber has carefully examined each call in the Green Network, but to be satisfied beyond reasonable doubt that that was indeed what was occurring, and that no other reasonable conclusion is available from the evidence, each call has to connect to evidence of what was occurring when the calls were made. Despite the 80 brief calls made over 4 months, the trial chamber cannot reconcile their timing and the location of the callers with the prosecutor's pleaded allegation that Mr. Badreddin was at the peak of a conspiracy to commit a terrorist act in murdering Mr. Hariri. The calls have no content, and finding context from their timing and location is very difficult. There is also no evidence of what was said in the calls, nor of any meetings between Mr. Badreddin and Mr. Ayyash. One call, on 14th of February 2005, appears connected to the attack on Mr. Hariri. The remaining calls, however, cannot be linked to anything directly connecting to Mr. Hariri, his movements, or any other evidence relating to the conspiracy pleaded. Therefore, it is not the only reasonable conclusion from the evidence that the Green Network acted as the mission command to coordinate Mr. Hariri's assassination. This does not alter the trial chamber's conclusions in relation to Mr. Ayyash. It is not necessary that the trial chamber find that Mr. Badreddin had the pleaded role alleged by the prosecutor to find that Mr. Ayyash participated in the conspiracy. The trial chamber, with Judge Brady dissenting on whether it should make legal findings on this issue at all, is not convinced that Mr. Badreddin had the role pleaded in the amended consolidated indictment. Judith? Turning to the disposition. The trial chamber, therefore, finds Salim Jamil Ayyash guilty as a co-perpetrator of Count 1, conspiracy aimed at committing a terrorist act. Count 2, committing a terrorist act by means of an explosive device. Count 3, intentional homicide of Rafiq Hariri with premeditation by using explosive materials. Count 4, intentional homicide of 21 persons in addition to the intentional homicide of Rafiq Hariri with premeditation by using explosive materials. And Count 5, attempted intentional homicide of 226 persons, in addition to the intentional homicide of Rafiq Hariri with premeditation by using explosive materials. The trial chamber finds Hassan Habib Merhai, Hussein Hassan Onesi, and Assad Hassan Sabra not guilty of all counts charged in the amended consolidated indictment, namely counts 1, 6, 7, 8, and 9. Judge Nosworthy has appended a comprehensive separate opinion analysing several discrete aspects of the interpretation of the applicable law, including on the definition of terrorism and customary international law, and on accessorial liability. Judge Brady, as has just been mentioned, has written a short dissenting opinion confined to the legal issue of whether a chamber may analyse the criminal liability of an absent alleged co-accused once the name is removed from an indictment. I have written a declaration expressing concerns about potential violation of Hassan Habib Merhai's fair trial rights during the trial. I have also appended a separate opinion concerning several procedural aspects of the proceedings, including delays in the pretrial phase, and that neither the United Nations nor Lebanon has yet publicly recognised the injustice caused by the lengthy, unlawful detention of the four generals, unquote. The separate opinions, the declaration and the dissent are all on separate and distinct issues of concern to the individual judges, the three of us, and do not affect the result of the verdicts, which are unanimous. There are several other issues we have to deal with today. The first is, Madam Court Officer, I ask you to distribute the copies of the judgment, which is in 5 volumes, 2,641 pages, to the parties and the participating victims. Can you please do that? Court officer is also handing to the parties and the legal representatives of victims a 149-page document entitled Summary of Judgment, which is the authoritative and abbreviated summary of the judgment, and it is footnoted, each paragraph is footnoted to the relevant paragraphs in the judgment itself. Concerning a transcript of the proceedings, there was no live transcript available today. The English transcript will be available, I'm informed, within 24 hours. The Arabic within 48 hours. The French, unfortunately, will take a little bit longer and will not be available until the 28th of August. The summary of the pronouncement of judgment, which the three of us have just read onto the record, will be available on the website very soon, the Tribunal's website. In relation to sentencing under Rule 171 of the Tribunal's, Special Tribunal's Rules of Procedure and Evidence, the proceedings are what we call bifurcated. That means there are distinct separate proceedings which follow a conviction. The trial chamber is minded to make the following orders to the parties. That is, the prosecution is to file its submissions on sentencing by Tuesday the 1st of September 2005, and the Ayyash defence is to respond with its written submissions by Tuesday, the 15th of September 2005. 2020. Oh dear. Tuesday, the 1st of September 2020 for the prosecution, and Tuesday, the 15th of September for the Ayyash defence. Mr. Hannes, I take it that presents no difficulties for you, and Mr. Farrell? Mr. Farrell's indicating no. Mr. Hannes is also indicating no. We are not setting a word limit. The trial chamber is flexible with this. We would rather be properly informed than try and restrict you to artificial and arbitrary word limits. In relation to a hearing, if necessary, once we have reviewed the prosecution and Ayyash sentencing written briefs, the trial chamber will decide whether it needs to have a hearing. If it does, we will hold a brief hearing, probably in September, as soon as possible, as soon as we can after receiving the written submissions from the parties. We will also issue this afternoon an order which will annul the arrest warrants against the 3 accused who have been acquitted. That is Mr. Sabra, Mr. Onesi and Mr. Merhai. That completes the proceedings. We thank everyone who has participated for their work in this. I turn to the victims and I just wish to say to you, we sincerely hope that the verdict today can give you some form of closure. In no way we understand can you ever be satisfied by anything we say, but we hope that we in some way can give you something out of this. So we thank you again very much for coming, and we wish you well on your return to wherever you go. The proceeding and the court is adjourned.
All rise, veuillez vous lever. تفضلوا بالوقوف.